ಅದೇ ಸರ್, ಅದರಲ್ಲಿ ಅದು ಕರೆಕ್ಟ್ ಏನು ಅಡ್ವರ್ಸ್ ಅದು ಏನಾಯ್ತು ಅಂತ ಕೇಳಿದ್ರಿ. ಹಾ ಸರ್. ಇಲ್ರಿ ಅದನ್ನ ನೆಗೋಷಿಯೇಟ್
number 35, I appear for the respondent, 35, I appear for the respondent. 2009. There was a review petition pending in the Supreme Court, Some review petition was pending in the Supreme Court, because of which the matter was not moved by the revenue. Last time they had mentioned saying that the matter is pending before the Supreme Court. I don't have instructions on whether the review petition has been allowed or not. That's why I just want a short accommodation. I've informed my learned friend also. I'll
Serial number 20, my lord. Serial number 20, my lord. Yes, my lord. This one. For the petition, my lord. For compliance, my lord. 2 weeks time, I believe. Ado legible copy on page number 180, the typed copy of the entire order sheet I have to produce. Please.
Orders. Number 1, Petitions under Land Grabbing Act. That has been paid, my lords. Has been made good. Please. May permitted, my lords, pass. My lords, to the that is, my lords, Advocates Welfare Fund. Please. Lords, please. Lords, proceedings under my lords Land Grabbing Act initiated, my lords, against the my lords the institution. The lands, my lords, in fact, not the in the same survey number, my lords, different pieces of land, my lords, which are adjoining, were allotted to, my lords, or rather granted to the petitioner society by, my lord, the then Maharaja, my lord, His Excellency the Maharaja of Mysore. Your lords may have a look at, my lords, annexure. Please. My lords, a different extent of land, my lords, has been provided. And my lord, subsequently, we are in possession, my lords, in the year 1914, 16, 1923, my lords. 4 ಎಕರೆ ಅಷ್ಟು ಬರುತ್ತೆ. Annexure D onwards. What happened, my lords, the report was called for by, my lords, the court by from the BBMP. BBMP submitted its report. If lords kindly have a look at, my lord, the report which is filed. In otherly there, Annexure Q, page number 78. 78, yes, my lords. If lordships come to 79, lords, second paragraph onwards. ಹೌದು. ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಆದರೆ ಎದುರುದಾರ ಸಂಸ್ಥೆಯವರ ಹೆಸರಿಗೆ ಪಾಲಿಕೆಯಲ್ಲಿ ಖಾತಾ ಅಗಲದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅಂದಿನ ಮೈಸೂರು ಮಹಾರಾಜ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಫ್ ಗವರ್ಮೆಂಟ್ ಆಫ್ ಹಿಸ್ ಹೈನೆಸ್ ದ ಮಹಾರಾಜ ಆಫ್ ಮೈಸೂರು ಆದೇಶ ಸಂಖ್ಯೆ 96/11/16 ಮಹಿಳಾ ಸೇವಾ ಸಮಾಜಕ್ಕೆ 2 ಎಕರೆ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿರುವ ಕುರಿತು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪತ್ರಕರ್ತರ ಅಲ್ಲ ಡಿಫರೆಂಟ್ ಎಕ್ಸ್ಟೆಂಟ್, my lords. They also make mention of the other extents, my lords, in the below paragraph. Please. Adರಲ್ಲಿ ಒಂದು portion of it, my lords, is given to KPTCL also. Road formation KPTCL ಗೆ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ. My lord, cognizance was taken. My lords, we were issued, my lords, with, my lords, the summons and also with the warrant. My lords, we have. Hello, either, oh, you, please, I am, my lords, I understand. My lords. I'm sorry. Please. Please, please, please. Yes, ma'am.
Section 9B of 2011.
Please. Please.
Section 227 and 228
Of CRPC. My lords, what I'm trying to submit. Yes, yes, my lord. I understand. I'm sorry, my lord. Subsection 3, my lords, of section 9. All alleged acts of land grabbing shall be tried only by the special court constituted for the area in which the land is situated, or where there are more special courts than one for such area by such one. Please. Nine, sir. Every finding of the special court with regard to any alleged act of land grabbing shall be conclusive proof of the fact that land grabbing and of the persons who committed such land grabbing, and every judgment of the special court with regard to the determination of title and ownership to or lawful possession of any land grabbed shall be binding on all persons having interest in such land. It's 8. Please. It shall be lawful for the special court to pass such order as it may fit to advance the cause of justice. It may award compensation in terms of money to wrongful possession of the land grabbed, which shall not be less than the amount equivalent to the market value of the land grabbed, as on the date of the order, and profits accrued from the land payable by the land grabber. Please. Every finding of the special court with regard to any alleged act of land grab. Yes. Please. 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 My lords, I may rely upon my lords subsection 2 because we are my lords. I couldn't. That is my lords. Vexatious, my lords. I could not get. My lord, that has been. It appears, my lord, substituted, my lords, with effect from 2020. It has been omitted. If my lords of substituted, my lords, as such, my lords. Please. Please. But the cognizance, my lords, was. Please. That is right, my lord. What I'm. Please. I am. Please. My lords, I understand. My matter is of my lords 2020. My lords, at that time, my lords, it was my lords just getting my lords fruitified. My lord, my submission is this. My lords, ಅಲ್ಲಲ್ಲ ಒಂದು ಹೇಳ್ಬಿಡ್ತೇನೆ ನಾನು ಕಾಗ್ನಿಸನ್ಸ್ ತಗೊಳ್ಳುವಾಗ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ Please. 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 Please, ma'am. Please, ma'am. Please, ma'am. In my case, my lords, if lordships kindly see, my lord, I am sorry. I am sorry. Please, I am sorry.
Personal appearance சொல்றது இஷ்டலா சமஸ்ய இதே மேஜிஸ்ட்ரேட் போர்ட்ல ஸ்பெஷல் application ಮೇಲೆ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ ದಿ ಔಟ್ಕಮ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಯುವರ್ ಪರ್ಸನಲ್ ಅಪಿಯರೆನ್ಸ್ ಈ ಎಲ್ಲ ಮಟೀರಿಯಲ್ ನಾವು ಮಿನಿ ಟ್ರಯಲ್ ಹೋಲ್ಡ್ ಮಾಡ್ತಿರೋದ್ರಿಂದ
my lords, no dispute, but let me, my lord, submit this. If lordships kindly see the order dated 24/10/2019, my lords, of which, my lords, I am aggrieved of, page number 27, my lord. The BBMP says it is not possible to determine as to where, I mean, whether the land is encroached or how much it is encroached upon. But what the finding arrived at by, my lords, the special court, if lordships kindly see the order dated 24/10/2019, it says, peruse the report submitted by the Joint Commissioner South Zone BBMP Bangalore with enclosures. The report discloses that an area of 31,951.67 square meters of land in survey number 7 of Dodda Velankare tank area is grabbed by respondent number 1 to 7. Based on the report and its enclosures, cognizance for the offence punishable under section 43 of the Karnataka Land Grabbing Prohibition Act is taken against respondent 1 to 7. Lords, there is a finding, my lords, if, please. Prima facie, my lords, fine. My lord, my lord, with that observation, my lords, if I'm, my lords, permitted to, my lords, please, man, it should not be. Please.
Even on the basis of material on record of the activity, and more particularly the report of the GPMP petition, the land in question has been allotted to the petitioner the then Maharaja of then government of Maharaja of particulars of which are made available to the session or the very report itself. That having not been converted to the documents have been wrongly taken, therefore the proceedings are voided.
It's not a child's play. Wide Pepsi Foods versus Special Magistrate. Not correct, huh? AR 1998 SC 128. 7. Seeking quashment of the proceedings, comma, he presses into service the apex court decision in state of Haryana versus Chaudhary Bhajan law. First, next paragraph. Learned AGA, your complainant.
I am for BBMP, BBMP.
Learned panel counsel appearing for the BBMP and learned HCGP appearing for the party Madilla HCGP on request submits on submit that the BBMP has already filed the report is true. Semicolon. Said report mentions about the grants made by Maharaja government is also true. Semicolon. However, all that would not come to the aid of the petitioner, who has got an alternate and equally efficacious remedy of invoking discharge provisions under section 9(3), read with section 9 of the 2011 Act, read with section 227 of CRPC 1973. First, they tell us that a writ court exercising a limited supervisory jurisdiction under Article 227 of the Constitution, Article 226 having been employed, ornamentally employed in the petition, notwithstanding, cannot hold a mini trial. First, so contending, they seek dismissal of the writ petition. First. Next, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission made by the respondents, answering respondent, and also the learned HCGP. First off, almost more or less similar fact matrix, we have done the same. Wide. Our WP number kodbekama, which is that WP other day we disposed of this. Next paragraph. The above being said, liberty needs to be reserved to the petitioners to seek discharge at the hands of the special court, making use of the material available on the complaint, which obviously would include the report of BBMP, which does not find advertence in the order taking cognizance. First off, had it been adverted, it would have been ideal. First off, be that as it may. Next paragraph. Learned counsel appearing for the petitioner is right in submitting that the launching of criminal proceedings is a serious matter. Wide Pepsi foods. First, however, the hardship can be mitigated if the petitioners are granted exemption from personal appearance till after their application in contemplation for discharge is heard and decided in accordance with law. First, in the above circumstances and with the above observations, this petition is disposed of, keeping open all contentions of the parties. First, registry to send a copy of this order to with that private complainant.
It's not a present, he is not a present. First respondent.
Party no madilva?
Respondent.
First respondent by speed post immediately. Registry to send them. Cost made easy. Cost made easy. I mean, please. Okay. Yes.
Serial number
Hold
2.
this phone.
Yes, brother.
I'm for the complaint in this case, my lord. In this
Ah.
case, as per the order reinitiated, my lord, but back wages, which is agreed by us, 50% there, that was not complied, my lord.
Back wages not paid.
But my instructions as of this morning is there is full compliance. I have
Morning.
requested, as of this morning, they said that full compliance has been made. I have requested for a copy of the treasury challan so that I may submit it before your
Right.
lordships.
We'll have this next week,
Week after
Please.
next.
week after next,
I will answer.
or week after next, at the request of learned AGA, who submits that he would confer with his clients and come back. Yes,
Any date,
Bharat.
please.
Next.
We'll take fresh steps, my lord.
First steps to be
May I
taken.
request, my lord, we'll take hand summons also.
Take
Permitted.
conventional first steps, semicolon. In addition, the appellant to take hand summons to. Okay. Immediately.
My lords, I have taken the process, my lords. Needful has been done. In addition, my lords, I take the hand summons, my lords.
Needfully stated to have been done. Hand summons ತೊಗೊಳ್ಳಿಕ್ಕೆ ಬರಲ್ಲ ಅದು. Criminal matter ನಲ್ಲಿ ಏನಿದೆ ನಮ್ಮ rules ನಲ್ಲಿ content rules ಇದಾವೆ ನಮಗೆ separate.
Income tax, my lords. ITA, item 4, my lords.
Item 4, sorry. Right. Item 4. You are right. Hand summons to be taken to the unserved party. Immediate. Okay. Yes.
Lordships, I filed this petition for initiating the contempt proceedings against the accused husband.
Or
Two incorrect orders were passed on the 30th October 2023 and 6/12/2023. And this court is hearing the application for correction. And on the last hearing, that is on the December 9th, 2023, the court had verbally mentioned that the court will recall the order. This is a recap of what we have done so
only
far.
you have only mentioned means we are yet to hear ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ. Contempt ಎಲ್ಲಿದೆ? ಏನು what is that contempt they have committed?
Contempt, my lordship, can you please refer to the annexure A?
This is already disposed of.
Yes, it was disposed of on the 30th October, following which I have submitted an application for correction, which is being heard. We've entered into a settlement, my lordships, and this was submitted to the family court in 2014 by way of an affidavit. And the terms of the affidavit have been,
Yes.
The affidavit was submitted, my lord. That is pending adjudication before the trial court. She has claimed compensation in the trial court and files a contempt petition here against my claim. Both ways. Your Honor, may I kindly see annexure?
Really? ಈಗ
Yes.
the powers of the writ court, powers of the writ court
Yes, my lord.
are co-extensive with the powers of the courts below, whose proceedings are being examined here.
Yes.
Number one. So, just amount claim ಮಾಡಿದಾರ. What is
lordships,
that amount they have?
I have not claimed for any
Amount.
compensation. So this terms of the affidavit, which are there as part of the undertaking, is part of the order. Now, this was done way back in 2014, your lordship.
Let us see that affidavit.
Affidavit is in page number 9 of the petition, which is annexure A.
Sorry.
I read it. We are ready and willing, page number 10, your lordships, that is the typed script. We are ready and willing live together without any conditions to each other, except the husband has agreed to set up a matrimonial home at Bengaluru for his family and will be shuttling to Bangalore on weekends and other holidays as long as required, and he will continue in present job at Madurai. In view of the facts, the above case may be disposed of in the ends of justice. Based on this settlement, the family court had passed the order way back in 2014. The order is in page number 11. Page number 12, your lordships, para number 2. The petitioner and respondent filed a joint affidavit that they are ready and willing to live together without any conditions, and the respondent has agreed to set up a matrimonial home at Bengaluru for his family and will be shuttling to Bangalore on weekends and other holidays as long as required, and he will continue his present job. This is the content
Alex,
of.
sit down, sit down, sit down, sit down.
Without any conditions, Your Honor.
Correct.
Coordinate bench is also in MC 528, which she is referring to. No decree was drawn.
Sorry. You
Right,
have
Your Honor.
made,
Yes, my lord, I'll come to that.
you have made
Yes,
a representation to the family court.
yes, yes,
Seriously,
yes,
saying we will do it together.
yes,
I have to make a separate matrimonial home
yes.
and I shall shuttle from between Bangalore and Tumkur,
Madurai,
Madurai.
yes,
That is the impression which you have given to the court.
yes, my lord.
So court has made that order.
Yeah.
Orders of the court have to be construed.
Yes,
Apex court says, keeping common sense not in cold storage. These are the words of the apex court.
yes, my lord.
Now,
I'll come to that. In view of this order, I took up a residence in Madurai. I took up a residence in Bangalore. I have not filed my detailed objections. I was waiting for this order in respect of this application, my lord. I prepared the detailed statement objection along with the documents.
when will you do?
Once this is disposed of, my lord, I will file my objection statement.
No, why, what is that disposal now?
In
This matter
respect
is
of,
before
in
us now.
respect of the correction, my lord. What is the correction? Your Honor may kindly say, what is the error?
What is the matter pending before the court below now?
There is a divorce petition pending. There is a criminal case pending. There are 3 more cases pending before the trial, before the family court. Connected to, from 2014, it has been, 2008, it has been going on.
All right. When you had given this undertaking to the court,
I think somewhere in 2014, man.
21/9/2014.
14, man.
Whether your client wants to adhere to undertaking,
Pardon me?
whether your client wants to adhere to this undertaking,
No, my lord.
he does not want.
No, so the water has flown, sufficient water has flown. The question of coming back, even if I have made 2 houses, one in Madurai as well as in Bangalore. She never bothered to stay with me. We were married only for 45 days. But I'm suffering for the past 19 years because of this marriage. It's become an irretrievable marriage, man.
That's all right. But suppose we are just putting to you, suppose, because there are very arguable points. These are matrimonial matters where constraints of law have to be little eased so that matrimonial justice is done. Suppose if we are just thinking aloud.
But
Suppose if we are telling it to both of you, we are
Yes,
just exploring the possibility of options. If we direct the court below to decide these matters afresh within the time frame of 4 months, 6 months, will it be all right?
yes, I'm ready.
Lordships, I have a couple of submissions to make. There is also the objections of the respondent. Kindly refer Annexure C, your lordships. This is the writ petition order of the Honorable High Court.
Annexure?
Annexure C. Annexure C of the objections from the accused.
No, there are, we'll see that. That's no issue. We'll see that also.
Lordship, just one paragraph that will, this is in page number 16, or from the court order, it is page number 10. This writ petition was filed before the Honorable Court, primarily because they were harping for the decree, because I'd filed an execution petition for this order to be executed in the family court. And this order has taken me 2 years, my lordship. I've earned this order.
No,
And
but
after having, in this order, the entire matter was perused.
correct, but where is the order?
The order is in, this order is for getting the directions to draw a decree.
Where is
There
the order? You have withdrawn the petition.
Yes.
Unless petition is there,
Hmm.
the question of decree will not arise at all. Where you have
Dismissed as
withdrawn the,
withdrawn, my lordship.
Nothing.
In view
Withdrawn,
of
I-
the settlement, the petition has been dismissed as
in
withdrawn.
terms of settlement, no order is made. Court acted upon your submission, permitted you to withdraw the petition.
The order has been drawn, your lordship. Based on the directions from the High Court, the family court has already drawn the order.
Where
Which
where
is
is
not-
that?
Lordships, in page number 10, this is the directions from the High Court to draw the order. And the order was drawn during the course, which is on the 5th of August, 2024.
Page number?
Lordships, I'm providing the decree. It was not then when I had filed this application. Lordships, I have one certified copy.
Very good. No. Brother, do you have just see this?
I've seen that, man.
You have seen that?
Yes.
The
It
decree
is,
is,
I wanted to file along with objection statement.
anyway,
I-
the
I-
decree,
Yes, madam.
decree is drawn.
Decree is drawn after the order of the honorable court, High Court. Yes,
Decree you have to abide by.
yes. Decree is drawn, madam.
Decree you have to abide by,
Yes,
unless it is set aside
yes,
by known source of,
yes. She is in Bangalore. He is in Haryana and also Tamil Nadu.
ask your client to come here.
I'll
So
ask
that we
him.
will try. Because there is a, rightly or wrongly, there is decree. Whether it amounts to contempt or not is arguable. That's
madam.
another thing.
Yes,
That's the reason we had issued notice to you.
that's madam.
But that apart, we'll explore the possibility of asking the parties to adhere to what has been decreed now. We'll explore. Suppose if the parties do not agree, then other options are, many options are available.
I agree with you,
Is
Lordship.
it not?
I agree with you. Lordship.
Some date we'll have this. matter.
Yes,
Lordships, before just a couple of submissions,
Not
Lordships.
necessary. Okay. Call this matter. Which date your client will be able to, you can't go on arguing like that. That's not the object of proceeding. That is the reason you are in trouble now. We have to make efforts to bring the parties together because that's the impression given to the court.
I have made,
Please understand.
I have made a.
Anyway, she's a
I'm
party.
sorry, I'm
She's
sorry.
a party in person.
I'm sorry.
So we have to.
I'm sorry. Yeah.
Which date will be convenient to your client?
3 weeks time, man.
For coming from which country?
Not from this country only. He has to come from Haryana. Now he is working at Haryana.
Which date? Fix a
He
date.
has recently joined 3 weeks. I request.
Hello, you tell them, we're giving you.
Last
That day he
week,
has to be here.
next month,
Head, have date, head.
4th or the 5th, anytime. Even 7th also is feasible.
Third of February.
Yes,
3rd of February, get here.
yes, ma'am.
All right.
Yes.
ಯಾವ್ದು Saturday working ಇದೆಯಲ್ಲ ಯಾವುದು? Of 25th of January. 25th of January is Saturday. We are
What?
sitting that day.
May not-
Ask Saturday is convenient for similar matters.
Yes, ma'am.
My
He has recently joined a month ago.
All right.
That's my.
3rd of February.
Yes, ma'am.
Yes.
Sir,
Call this
what's
matter.
the date, sir? On 3rd Feb?
3rd February.
Yeah, I'm also working, sir. I have to take a leave and then appear
Tell,
here.
choose one day, you tell another,
I'll go with 3rd February, sir.
no problem. If you have difficulty, we'll give another date.
No, I'm okay with that. sir.
Call this matter on 3rd of February. First off. Petitioner party in person, complainant party in person. And the respondent
The representative of the VIM.
shall be personally present
Yes, ma'am.
or are requested to be personally present before the court for exploring the possibility of some settlement without prejudice to contentions of the parties. Another? Correct. Okay. Yes.
My lord, amendment to cost title, my lord, I may be permitted to do it during the course of the day. Amendment.
ಮಾಡ್ಬಿಡಿ
ಈಗಲೇ
ಮಾಡಿದ್ಮೇಲೆ ಇನ್ನೊಂದು ಡೇಟಿಗೆ ಇಟ್ಕೊಳ್ಳೋಣ ಅದನ್ನೆಲ್ಲ ಮಾಡಿ ಯಾವಾಗ ಮಾಡ್ಬೇಕಿತ್ತು
ಇವಾಗಲೇ ಮಾಡ್ತೀವಿ ನಾವು.
ಅಲ್ಲ ಯಾವಾಗ ಮಾಡ್ಬೇಕಿತ್ತು
ಯಾವಾಗ ಮಾಡ್ಬೋದು?
2024.
In fact, my lord, we tried to.
ಮಾಡಿ ಬೇಗ ಮಾಡಿ ಕೊಡಿ. Call this matter. Next week we'll have that. Amendment to be effected before sunset of the day, failing which benefit of amendment would wither away. Okay. Yes, Narsim Raju.
This matter pertains to disobedience of the order of the land single judge.
Disobedience.
Decrease attained finality. Lordship has given sufficient opportunity to carry the revenue entries. Till today, from 2000, I am fighting for that. Decrease attained finality. Appeal was preferred. Lordship only given a time, but the appeal also dismissed. Kindly come to voluntary as Tahsildar has undertaken before the division bench of Lordship is also come.
What is that decree?
Decree for adverse possession was decreed. That was challenged by way of an appeal. The appeal was dismissed on 26/6/2024. Thereafter, Lordship has given an opportunity on 4/1/2024. Subsequently, on
No, how
10/7
contempt proceedings would arise here?
kindly come to the direction of the learned single judge. At page 49. The learned single judge specifically directed to carry out the revenue entries by virtue of the decree, page 49. The order is dated 17/1/2023. A positive direction was issued.
Yes, Aditya.
I need to speak to the current incumbent in A2, my lords.
A2.
But I'll do that personally. Maybe given about 2.
Because once RFA is dismissed and the apex court says we have to go on.
Continue. The suit is one aspect, right? I'm not sure who slept on the suit in number of matters at the Tehsildar level. But so far as compliance is concerned, I will speak to the current incumbent at A2 and
Choose one
make a
date
submission.
when he will say something.
A week of 20th, any date convenient to your lordships.
20th.
Week of 20th, any date convenient to your lordships.
Whichever date you say, that day we'll call this.
But 22nd or 23rd.
23rd.
One day on submission. ಏನಾಗಿದೆ 2013 ಅಕ್ಟೋಬರ್ 2023
ಡೇಟ್ ನಾವು ಕೊಡ್ಲೇಬೇಕಾಗ್ತದೆ.
ಅಲ್ಲಲ್ಲ ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಅಲ್ಲಿ
ಹೇಳಿ.
ತಮ್ಮ ಮುಂದೆನೆ ತಹಸೀಲ್ದಾರ್ ಬಂದು ಅಂಡರ್ಟೇಕನ್ ಮಾಡಿದ್ರು. ನಾನು
ಮಾಡ್ತೀನಿ ಏನೇನೋ ಆಸ್ಪೆಕ್ಟ್ ಇದೆ. ಸಿಂಪಲ್ ಇಲ್ಲ.
ಪ್ಲೀಸ್
ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಇದು. ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಆಫೀಸರ್ಸ್ ಅಪಿಯರ್ ಟು ಹ್ಯಾವ್ ಕಾನ್ಸ್ಪೈರ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ದ ಸ್ಟೇಟ್. So many aspects ಇದೆ.
ಪ್ಲೀಸ್
We'll look into.
ಪ್ಲೀಸ್
ಮಾಡ್ಕೊಂಡು ಈ ರೀತಿ ಅಡ್ವಾನ್ಸ್ ಪೊಸಿಷನ್ ಎಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ
That was in
ಉಳಿಯೋದು
2000.
ಹೇಗೆ ನಾಳೆ
97, 2000 ಅದು. ಈಗ
ಇದೆಲ್ಲ ಆಫೀಸರ್ಸ್ ಕಾನ್ಸ್ಪೈರ್ ಎಲ್ಲರೂ ಇದು ಎಲ್ಲ ಒಂದಾಗಿ ಮಾಡಿರ್ತಾರೆ ಇವನ್ನೆಲ್ಲ. ಎನಿವೆ ಲೆಟ್ ಅಸ್ ಸಿ. ನೋ there is rightly or wrongly there is an order in your favor.
appeal
Let us
also
see.
had that
ಅದೇ,
appeal also
no, no.
exhausted.
No, call this matter on 23rd
Please.
at the request of learned AGA. Yes,
Please.
ಅಲ್ಲಿ ನೀವು what action you have taken against officials who did not resist the suit?
I'll place that before you.
ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು. ಹಿಂಗಾಗ್ಬಿಟ್ಟು ಮುಂದೆ ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಉಳಿಯೋದು ಇಷ್ಟು ವ್ಯಾಲ್ಯೂಯಬಲ್ ಲ್ಯಾಂಡ್.
At least in this suit, the government is a party. There are some suits, my lord, that have.
Where
come to the-
government is not even a party.
Tehsildar is made a party.
Government has contested the matter. ಇದ್ರಲ್ಲಿ
No,
contest ಮಾಡಿದ್ದಾರೆ.
no, ಏನೇನ್ ಮಾಡಿದಾರೆ ಅಂತ. Otherwise public property. High Court is the custodian of public property ಅಂತ ಹೊರಡು ಮಾಡಿದೀವಿ ನಾನು ಸುಧಾರ್ ಸಾಹೇಬ್ರು. Apex Court has put its seal to that judgment. So many aspects. Let us.
Your appeal, my lord, remedies, my lord,
Yes,
already is availed.
Not
It is attained finality.
all.
Please.
Yes, Dilip.
Well, I'll take fresh steps, my lord. In addition, my lord, we may be permitted to take hand summons.
Fresh steps in addition to taking hand summons.
My lords, fresh steps have been taken today, my lords, today morning. In addition, my lords, I'll take hand summons.
No. Fresh steps are stated to have been taken. Full stop. Appellant shall also take hand summons. ಅಲ್ಲೇ ಅದಕ್ಕಿಂತ ಮೊದಲೇ registry to verify ಮಾಡಿ appellant has to take hand summons as well. Okay.
My lords, I'll file a better affidavit, my lords. Delay is also very little, my lords, but unfortunately, we've only filed a one paragraph affidavit, my lords.
Better
I'll do a
affidavit
better.
explaining the delay in support of the subject application to be filed within 10 days. Call after 2 weeks.
The petitioner, my lords.
Lord, we have complied with the order.
Complied.
Last time, your lordships have noted it in the order sheet.
My lords, they have just given me a statement saying that the pensions have been paid, but my instruction is 2 days back, a letter was sent saying that a letter has been sent to the CBDT for revise of pension. My instructions are that she's not received any arrears of pension, my lords. Now, just now across they gave me a statement. I have to verify, my lords, because she said that she's not received any pension arrears at all.
Why the central government will lie? You can revive if it is false.
Swami, last time ಇದು second time revive ಆಗ್ತಾ ಇರೋದು ಸ್ವಾಮಿ.
Correct. But now they have said, learned ASG is saying.
ಅಲ್ಲ ನನಗೆ ಲೆಟರ್ ಇದೆ ಸ್ವಾಮಿ. I'll just show the
Lord,
letter.
moreover, my lord, the direction was for promotion. Promotion we have already
Alla,
given.
promotion-
Consequential benefits she is asking. But that also we have complied.
Revised pension PP order.
Revised pension order has been made.
ಆರ್ಡರ್ ನ ಕಾಪಿನ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಅವ್ರಿಗೂ ಕಳ್ಸಿದ್ವಿ.
ಇಲ್ಲ ನೋಡಿ
No, please, ಅದ್ರಲ್ಲಿ copy ಇದೆ, copy it.
ಆಯ್ತು, ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬಿಡಿ.
ಸ್ವಾಮಿ
All right, next date ಒಂದು ಹೇಳ್ಬಿಡಿ. Next week,
ಆಯ್ತು ಸ್ವಾಮಿ.
call this matter. Tuesday sitting ಇದೆ ಅಲ್ವಾ? ರಜೆ, holiday. Wednesday. Wednesday.
Can it be Thursday?
Thursday.
Great.
Thursday. Yes, at the request of counsel for the complainant.
Bless you.
Yes, Dilip,
Lord, the matters can be disposed, my lord, covered.
covered by judgment. But the subject matter of these appeals, comma, it is unanimously submitted at the bar, comma, is substantially similar to the one
In the case of the same respondent.
Same respondent.
one in ITA number 12 of 2024, wherein the same respondent herein was the respondent. ಅಲ್ಲ ಕವರ್ಡ್ ಬೈ ಅದು ವೋಡಾಫೋನ್ ನಿಂದ ಕವರ್ ಆಗತ್ತೆ ನೋಡಮ್ಮ ಈ ಆರ್ಡರ್ ಸೇಮ್ ಆರ್ಡರ್ ಇದು ಬೇಡ ಆರ್ಡರ್ ಮಾಡೋಣ
Just, let me also record, I'll remove the objections today. I'll comply with the objections. There is some.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು ಇದನ್ನ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್
Yes,
ನೆಕ್ಸ್ಟ್
This matter, my lord, my submission is it can be disposed,
ಏನದು?
but I'm not conceding, my lord. The issue is, my lord, section 1192B, it empowers the authorities to admit an application for refund, deduction, exemption, etc. if it is beyond the statutory limit time.
Even when it is beyond.
Beyond, there is then, my lord, they have to prove genuine hardship and reasons and all that.
Like section 5 of Limitation Act.
But here, my lord, what has happened is, there is also a circular which says no application can be entertained if it is beyond 6 years. Now, in the present case, what has happened is returns were filed just beyond the statutory limit, not within 6 years.
But within 6 years.
6 years. But however, the application was filed after 6 years. Then, my lord, Kerala High Court has said, the issue is whether the claim has been made within 6 years,
Whether application or otherwise.
otherwise. Lord, I'll place the judgment, my lord, which has been followed with the learned single judge.
So learned single judge ಏನ್ ಹೇಳಿದಾರೆ ಅದನ್ನ ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ರೆ ಆಗಿ ಹೋಗುತ್ತೆ.
ಆಯ್ತು.
ನೋಡಮ್ಮ. Appeal
But I brought the, my lord,
dismissed, agreeing with the reasoning of the learned single judge in the impugned order dated 2/11/2023, entered in WP 16991 of 2023, filed by the assessee. ಏನ್ರ ಮೆಟ್ರಿ ಇದೆ ಬೇರೆ?
ಇಲ್ಲ, ನಾನು I'll just place the, just for academic purpose, my lord, I'll place the circular, my lord.
The CBDT another.
CBDT circular.
The CBDT circular number 9 of 2015 dated 9
Para 3.
9/6/2015.
This is where we rely.
At paragraph 3 reads as under. First one. Kerala High Court ಹೇಳಿದ್ದು if claim is made, whether application is filed or not.
ಅದು ತಂದಿದ್ದೀನಿ.
ಇದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದೀನಿ.
The
I'll
Kerala-
place judgment also.
The Kerala High Court in so and so having construed the relevant
In para
paragraphs
6. In
of
pa-
the said circular
In para 6.
has observed at para 6 of its all judgment as under. First of all, judgment to be framed that way. Also, registry to send a copy of the order. Okay. Yes.
It's an appeal against the order of the learned company, Judge Millard. Before we go into that, there is one aspect of the office objection on limitation. How last time also, whether it is 30 days or 90 days. And that. So here. As per the High Court rules, this has to be treated as a regular first appeal, Millard.
Then it is 30 days.
Then it is 90 days.
90 days.
As per Article 116 of the Limitation Act.
For within Bangalore city idru.
ಅಲ್ಲ ಅದು ತಾವು ಹೇಳಿದ್ರಿ ಇದು ಜಸ್ಟಿಸ್ ಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ನೋಡಿದೇವಿ. There also it confirms it is 90 days. 90 days.
I will leave it to your lordship's discretion.
Okay. Office objection ಇದೆ ಏನು? ಅವ್ರು ಯಾಕೆ
Office-
ಹೇಳಿದ್ರು?
The office objection, they say Article 117 will apply because it's any order of High Court to the High Court. Anta. But there is a distinction in this in as much as per the High Court rules, this has to be treated as an RFA.
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 If that is done,
Then it is 90 days.
automatically whatever is limitation for RFA will be the
Will apply
limitation
to
for
this,
here
yes.
also.
That's, so which is within that, which is within 90 days.
Accepting
But
submission of counsel appearing for the appellant, office objection to as to the requirement of filing application seeking
Correct.
continuation of delay is overruled.
very good.
Yeah,
Coming to the
merits.
the impugned order, my lord, this again, it's a short point again on limitation, my lord. Section 458A of the Companies Act, which talks about limitation for initiation of proceedings by a company in liquidation, which is by the official liquidator, OL, against, here the petitioner is an alleged debtor of the company in liquidation. The official liquidator filed an application before the company court for recovery of certain monies. The defense taken there was the claim itself is barred by limitation under 458A.
But
So let me read section 458A, my lord.
ಇದನ್ನ ಇನ್ನೂ ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ನೋಟಿಸ್ ಆಗಿದೆ.
I was on caveat, my lords.
You are on caveat.
I was on caveat.
We'll consider in the
Please, my lords, I may be permitted to file a brief synopsis on how I've arrived at limitation.
issue notice. The respondent is on caveat. First, call this matter.
Although literally they have, the lower court has ordered further evidence and all. The matter may be stayed till it.
Don't precipitate the matter.
Don't let them
This is
not-
decided.
Very well.
The proceedings in the court below shall not be precipitated till next date of hearing.
Very well.
Call after 4 weeks. 4 weeks?
Great.
Obliged.
Oh, notice ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. Okay. Notice to private respondents. Okay.
That was needful done, my lords. Additionally, my lords, I'll take the ransom.
Needfully stated to have been done. Registry to verify.
Yep.
Ah. Amit Deshpande.
Waiting for the petitioner, my lords. We are not in the record, so new,
You are not in a.
apologies. We are not in the panel, my lords. The new panel has to come.
ಯಾರಿದ್ದಾರೆ ನಿಮ್ಮ ಪ್ಯಾನಲ್ ನಲ್ಲಿ? Say Vishal Tiwari appears for the appellant. Registry to delete name of Deshpande Amit Anand. Okay. ನಿಮ್ಮ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಇದೆಯಾ ನಿಮ್ಮಲ್ಲಿ? ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ. The retiring counsel, Mr. Deshpande, shall hand over the papers to Mr. Tiwari immediately. Okay. Office objections to be addressed by Mr. Tiwari within 2 weeks.
Just give the papers to me. Give me the papers.
Yes, somebody?
I'll take 2 weeks' time, my lords, to comprise office objections, my lords.
Even 4 time ಇದು ಬಂದಿತ್ತು.
Yes, my lords. There's some difficulty, my lords. I'll just do it, my lords. I'll just do it as much as possible.
1 week for compliance, final.
This is that matter, my lords, after the KIDB matter, my lords, income tax, TDS on KIDB matter. Matter is now gone to Supreme Court, my lords.
My judgment.
No, that my lord's judgment is the NHI judgment, my lords. But this is on KIDB Act, my lords.
Okay. All right. Office of compliance to be done within 1 week.
Yes, lords.
Yes, Mr. Shekhar.
Court fee has been paid. Other
paid
objections,
already.
my lord, will comply within 2 weeks. There are typed copy has to be filed.
Again, this is 4 time.
Please, I think 3 times it's listed before registrar. Will comply within 2 weeks.
Compliance within 2 weeks, failing which appeal stands rejected on its own.
Okay.
Yes.
Yes, somebody?
Sanmati. ಇದು 4 time. Sanmati is not on panel ಈಗ.
No, he's my lords. He is my lords. He's another court, my lords.
But ಏನು 4
Court fee
time.
has been paid today morning, my lords.
You have paid already.
Yes, my lords. Court fee has been paid, my lords.
ಬೇರೆ other complaints ಎಲ್ಲ ಇದೆಯಲ್ಲ? 7
Yes, my lords.
objections
There is
taken.
also 4.
Come on.
There's-
Court fee is stated to have been paid. First up, registry to verify. Other office objections to be addressed within 10 days. Yes,
Petitioner, my lord.
yes.
The one office objection is the order sheet, my lord. I've produced the certified copy. The typed copy is required to be.
ತುಂಬಾ ದೊಡ್ಡದಿದೆಯಾ ಚಿಕ್ಕದ? Is it a big
It's my lord, what is printed is visible, my lord. Please to see in page 22 onwards.
visible?
Yes, my lord. Legible.
Translation. Office objection is overruled after hearing counsel for the petitioner. Appellant,
Petitioner, my lord.
petitioner. ಏನಿದು?
My lord, this is the petitioner's a real estate developer, my lord. he has developed a plot of land of 50,000 square feet. And in that, my lord, there is a press note which said that there was an encroachment of land of around 0.06 guntas by a Patel in company, my lord. Now, the petitioner being the developer of a property, which is in survey number 38/1, has put up an apartment building after getting the occupancy, and he has also obtained the occupancy certificate from the BBMP. My lord, based on the press release, there was a Sumoto proceeding started by the land grab court. And they have taken cognizance after hearing us, my lord. And the cognizance, my lord, is at order at ink page 16. The operative part is ink page 17. First paragraph, my lord, which says that this is a Sumoto case initiated under Section 9, subsection 1 of the Karnataka Land Grabbing Prohibition Act, based on the report published on Vijay Karnataka dated 19th January 2017, under the caption of Raj Kalve Vattuvari Teruvu. The report carried that BBMP Bangalore has cleared the Raj Kalve encroachment of 0.06 guntas on the main RT Nagar and Dinur road, and also compound wall illegally constructed by Patel in club in the same premises. My lord,
But there is an order by the revenue authority that you have encroached.
No, my lord, this is a press release. This is a press in the Vijay Karnataka newspaper.
Come to para 6, page 19.
Yes, my lord. Para 6, page 19.
Yes.
Before that, my lord, yes, I'll read that. Further, the argument of the respondent that the Karnataka Land Revenue Act has set out a detailed procedure to be followed by the revenue authority, that respondent is myself, my lord, to ascertain if any person has encroached the government land, and in instant case there is no order by any authority under the Land Revenue Act to conclude that the respondent has encroached on any government land on the stormwater drain, does not hold water, as a case on hand is filed under Section 9(1) of the Karnataka Land Grabbing Prohibition Act 2011, which special courts have power to register Sumoto cases if it comes to its knowledge that a person is alleged to have grabbed government land. Section 9(1) states the special court may either Sumoto or an application made by any person, officer, or authority take cognizance of and try every case arising out of an alleged act of land grabbing or with respect to ownership, title to, or lawful possession of the land grab or offences specified in chapter Roman numeral 14-A of the Land Revenue Act, whether before or after the commencement of this, and pass such orders by way of interim direction at the deemed fit. Thus, the Act provides for a special court to take up cases either Sumoto or on an application made by any person, and therefore the arguments of the respondent that only revenue authorities have to determine whether any person has encroached government
That
land.
cannot be accepted.
Please,
Your
my lord.
contention cannot be accepted.
Yes.
The very purpose of special court is to make an investigation and hold it.
My lord is pleased to see the BBMP, my lord, had issued a tender, I think page 122, where they have, my lord, this is the RT Nagar, my lord, there's a stormwater drain, and they have formed a layout to a large extent. And when they form a land, my lord, they can do engineering under and over the land to reform the Raj Kalves, etc. And the photographs, my lord, which is at ink page.
Correct. All these things are cognizance cognizance to face that.
Page 129, my lord is pleased to see, my lord. This is what is built by the BBMP. BBMP has built it. All I'm saying, my lord, is I am the developer. My difficulty, my lord, is because the cognizance is taken considering my objections. That way, my lord, because the criminal procedure code applies, I would at least, if the cognizance was taken on its own, based on the, not based on the report of the newspaper, but based on an inquiry conducted under the Land Revenue Act to fix that, which is this 0.06, because I am only a developer and I have already got the occupancy certificate, which is at ink page.
Developer means you also will have interest in the land.
My lord, I have put up apartment buildings.
Therefore, you
and
have
I sold
interest in
it. I sold the apartments. Landowner has also been made an accused.
Yes.
Landowner has also been made an accused. If anybody would have encroached, my lord, it would be the landowner. The only, my concern, my lord,
Suppose
is.
if a landowner has encroached.
Yes.
And you put up construction on that.
Yes.
You do not commit encroachment.
My lord, I bow down to what for. Please see page 121, my lord. Please see page 121 is the occupancy certificate.
That makes no sense.
All I would request, my lord, that the cognizance would normally be taken without hearing my defense.
Correct.
So now,
They have shown some concession to you that you were heard before
my
taking
lord, what happens is, it preempts me from filing an application for discharge. If my lord, with discharge on the basis of the record, I would be entitled to file an application for discharge.
We'll make that observation.
Yes, my lord.
Okay.
And my learned friend was just saying, my lord, it was regarding Patelin, but my lord is pleased to clarify,
That's
my
fine.
lord, that all, without dehorse the observations are.
Cognizance order.
Yes, my lord.
Generally, discharge question arises after cognizance only.
Yes, my lord.
That's how Hardeep Singh says
Yes,
that way.
grateful, my lord.
That way.
The only thing is
You
because
were
of this.
heard at the stage of taking cognizance does not preclude you from seeking
Yes.
227.
Yes, ma'am.
Parkadi. Challenge is to the order of the special court whereby cognizance, Kutakadi, please be
Please,
seated,
ma'am, please.
for the offences punishable under 2011 Act has been taken. First, learned counsel for the petitioner vehemently argues that though the special court has got power to take Sumoto cognizance, that cannot be done based upon the newspaper report. First, he further submits that to initiate criminal proceedings as to the encroachment of public property, the investigation or inquiry has to be preceded at the hands of the revenue department. First, so content arguing he seeks invalidation of the order of taking cognizance. First, error party that learned AG appears or you appear? Learned AG appearing for the official respondents opposes the petition. Mr. Bhatt, do you take notice?
I take note.
Mr.
Classification
AGA
but I take note.
appearing for the official respondents opposes the petition, contending that the petitioner can move discharge application under the provisions of Section 9 of the 2011 Act, read with Section 227 of CRPC 1973, as has been held by this court in similar cases. First, that being the alternate and equally efficacious remedy, he submits, writ court shall not grant interference. First, next, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission made by learned AGA and therefore decline indulgence. First, the apprehension of the counsel for the petitioner that since cognizance is taken after hearing his client, the special court may not entertain the application for discharge may not be correct. First, at the stage of taking cognizance, sometimes the court hears the accused, although it is not a legal imperative. First, once cognizance is taken, only thereafter the application for discharge can be moved, hardly needs to be stated. First, next paragraph. In the above circumstances and with the above observations, this petition is disposed of. One more sentence hardly needs to be stated. No prejudice would be caused to the petitioner, since in similar matters, we have granted exemption from personal appearance till after the call is taken by the special court on the discharge application to be moved by the petitioner within 2 weeks.
Wait for me.
2 weeks. First.
My lord, with
All
the
contentions are
uninfluenced
kept
by the order of the.
All contentions
Yes.
are kept open.
Grateful, ma'am.
Lordship, this matter, I'm led by senior counsel, your lordship. Serial number 33 also connected.
21 and 33.
33, your lordship. Senior counsel, he'll come at a
Passover
time.
mana and data.
Passover, your lordship. Serial number 33 is taken up.
21, 33. Yardano Passover.
When serial number 33 comes, we'll, when serial number 33 is taken up,
He will argue.
Yes.
In the 33 jade contract. Okay.
In this case.
Yes,
2 weeks
Pasha.
time level.
ಏನದು objections?
Non-compliance.
4 times.
ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ದೇವೆ 2 weeks ಟೈಮ್ ಅದು ಡೆಲ್ಲಿಯಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕು ಕಾಪಿ ಸರ್.
All right. 2 weeks finally for compliance, failing which the the petition stands rejected peremptorily.
For the petitioner,
Ah.
there are 2 office objections, Manoj, one pertaining to translation and the other production of typed copies.
Typed
My
copy.
submission,
ಬರಲ್ಲ
Manoj,
ಅನ್ನೋದು ಕೊಡಿ.
legible copy.
Sketch legible copy na ಕೊಡಿ. ಯಾವುದು annexure ಏನದು?
L, Manoj. Annexure L at page number 227.
227.
I will, my submission, Manoj, is that the office objections pertaining to translations, Manoj, may be dispensed with.
Translation dispense ಅದನ್ನ ಇದನ್ನು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನಿಮ್ದು ಎರಡನ್ನು
I will produce the legible copy, Manoj, in.
ಅಲ್ಲ ನೋಡಿ ಇದೆ ಸ್ಕೆಚ್ ಅದಲ್ಲ 227
Please.
ಇದೆಯಲ್ಲ ಏನ್ ಲೆಜಿಬಲ್ ಕಾಪಿ ಇದಕ್ಕಿಂತ ಹೆಚ್ಚು ಲೆಜಿಬಲ್ ಇರ್ತದ ಇಂಗ್ಲಿಷ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಆಫ್ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಈಸ್ ಡಿಸ್ಪೆನ್ಸ್ಡ್ with for the time being, but because we don't know, the other bench may require that. The office objection as to illegibility of the sketch at annexure L, annexure so and so is also dispensed with. Any the matter, brother?
I am appearing on behalf of the council for the petitioner.
You are counsel for the council.
Council for the council.
Then
These
you have to
office
argue matter then.
objections may be overruled, Manoj, or dispensed with. And the matter may be posted for hearing, Manoj, on a given date.
In representation of. Consider the representation, ಅಷ್ಟೇ ತಾನೇ?
Please.
Learned HCGP is requested to accept notice for first issue notice. Accept notice for response number 1. BDA ಕ್ಯಾರಿದ್ದಾರೆ. ME Charate, learned senior panel counsel is requested to accept notice for response numbers 2 and 3 ಅನ್ನ. Committee 2 and 3. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ.
Please, answer.
Call after 4 weeks. And the petitioner to serve copies on so and so. Okay. ನೀವು ಹೋಗಿ ಫೀ ಇಸ್ಕೊಂಬಿಡಿ ಫುಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾನೇ ಮಾಡೀನಿ ಅಂತ ಹೇಳ್ಬಿಡಿ. Yes.
10 days delay.
Application supported by affidavit seeks delay, condonation of delay of 10 days. First off, explanation offered being plausible, application is favored and delay is condoned. Yes. Next.
Pray for time to file better affidavit, my lord. And matter is also identical issues pending before the Supreme Court in review petition, my lord. The tribunal has followed judgment of Honorable Supreme Court in case of engineering analysis. In that case, we have filed the review petition, it is pending.
Arm's length price.
Illa adilla, idu royalty issue.
All right, better affidavit to be filed in support of application in IA number 1 of 2020.
Yes, my lord. Lordship, it may be adjourned for 4 weeks, my lord. Review petition ಏನಾಗುತ್ತೆ ಅಂತ ನೋಡ್ಬೇಕು ಅದಕ್ಕೆ.
All right, call this matter after 4 weeks so that
Yes, my lord.
the status of review petition pending before the apex court would be ascertained.
Please, my lord.
Okay.
I appeal for the complainant, my lords.
Ah.
We have filed an IA to revive the contempt petition.
ಏನದು?
Respondent, my lords, against a review petition, my lords, writ appeal has been filed, my lord.
Against stay ಆಗಿದೆಯಾ?
Stay ಆಗಿಲ್ಲ, my lords, it may be tagged along with this contempt, my lord.
ನಾವೇನ್
30th ಗೆ
ಮಾಡಿದ್ವಿ?
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, my lords.
Third,
30th ಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಮೇಲೆ ಅಪೀಲ್ ಇದೆಯಾ?
Yes, my lord.
ಅಪೀಲ್ ಹಾಕಿರ ಈಗ?
I have
My lords,
challenged
they have
both the
fallen.
orders, my lords. Writ petition order and review petition order.
Both are in appeal now.
Yes, ma'am.
Learned panel counsel appearing for the respondent, ತಾನೆ?
Yes, my
Respondent
lord.
submits that.
My lords, writ appeal.
Writ appeals, ಎರಡು writ ಒಂದ?
One.
Writ appeal number so and so has been filed against the order whose violation is complained of.
My lords,
And therefore, he seeks 4 weeks.
My lords, it may be clubbed together. my lords.
ನಾವೇನ್ ಕ್ಲಬ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಅದು ಚೀಫ್ ಜಸ್ಟಿಸ್ ಮುಂದೆ ಕೇಳ್ತಾರೆ.
I'm, yes, ma'am.
Called.
Much.
Therefore, he seeks a period of 4 weeks. 4 weeks. First, call after 5 weeks.
Much.
There is short delay, my lord, it may kindly be.
ಏನ್ ಶಾರ್ಟ್ 435 days ಇದೆ.
27, my lord.
27, 42 days.
Yes, my lord.
ನೋಡಮ್ಮ, ಕಂಡು.
Your lordship, as far as merits of the case is concerned, transfer pricing issues, I have raised 6 questions, my lord, regarding comparison.
Similar matters we have admitted now, and other matter we are hearing also. You'll admit this appeal? Okay. This appeal is admitted. ಯಾವ question ಅದು?
Question 1 to 6, my lord, page number 8 and 9.
On the substantial questions of law, which read as under, ಅದು ಆರೋಪ questions. Next.
Complaint,
Krishna,
please.
ಏನಿದೆ?
I filed the application for revival of the contempt because they have not complied. The
Not
order
complied.
not complied. While disposing of the contempt, my lord, you will suppose please to observe the same. Even then, my lord, they have not complied. On 28/10/2024, my lord, my application was allowed and the government advocate was directed to take further instructions, my lord.
ತಿಳ್ಕೊಂಡು ಹೇಳಿ.
Not done.
I'm told that on 30/10, endorsement has been issued to the effect that if the Lebanese sketch is provided, the
Will do
compliance
that.
will be made in accordance with law. And I'm told short while back.
ರಿಕ್ವೈರ್ಮೆಂಟ್ ಏನದು ಆರ್ಡರ್ ಕೆಳಗಡೆ?
The order requirement is, my lord, I have to file application, online application along with the documents.
ಫಾರ್ ಇದು ಏನಿದು?
Coding.
ಕೊಡಿ.
Yes, my lord.
ರೆವೆನ್ಯೂ ಸ್ಕೆಚ್ ಕೊಟ್ಟು ಮಾಡಿ ಹಾಕಿ.
Produce, my lord.
ಎಲ್ಲಿದೆ
For
sketch?
schedule,
11E.
yes, sir, along with everything we have produced.
ಎಲ್ಲಿದೆ 11E? ತೋರಿಸಿ.
But along with application, we have produced. my lord.
ಇಲ್ಲಿ ತೋರಿಸಿ ನಮ್ಗೆ 11E ಇದೇನು ತೋರಿಸಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಅವರು. 11E ಕೊಟ್ಟರೆ ಮಾಡೇ ಮಾಡ್ತಾರೆ. ಬಿಕಾಸ್ 11E is a requirement now because of Supreme Court judgment.
Yes, my lord.
Hmm.
Please.
Learned AGA appearing for the respondents in all fairness submits that if the complainant produces 11E sketch, comma, the claim for coding another.
Yes, my lord.
Code ಅಷ್ಟನ ಬೇರೆ ಸರ್ವೆ and coding.
Coding, my lord.
Coding
Please.
would be accomplished.
But they have not
First
furnished the endorsement which they are.
He is saying now, we are recording it so that it will help you. He also has produced an endorsement dated
Minutes 30/10/2024.
30/10/2024.
I'll produce
Issued by,
No, the Tehsildar. my lord.
issued by the Tehsildar to the same effect. First up, it reads as under. Next paragraph. Next, in view of the above assurance of the respondents, the matter is disposed of. First up, it hardly needs to be stated that if the complainant produces the 11E sketch, comma, the 4D work would be undertaken and accomplished.
Please. Great.
At the earliest. Dispose of application. ಏನ್ ಬೇಕಿಲ್ಲ ಮ್ಯಾಟ್ರಿ ಡಿಸ್ಪೋರ್ಡ್ ಆಫ್ ಅಂದ್ಬಿಟ್ರೆ
Deeply obliged.
ಅಲ್ಲಿ ಏ ಅಲೋ ಮಾಡಿದ್ದು ರಿವೈವ್ ಮಾಡ್ಕೊಳ್ಳೋಣ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡೋಣ. Otherwise it may come in the way.
Earlier date, my lord, on 28/10/24.
ಅಲೋ ಆಗಿದೆ?
Yes, my lord. That application was on.
ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿಲ್ಲ. ಅಲ್ಲಿ ನೋಡೋಣ ಮೇಲೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬರ್ಕ. Application seeks revival of the contempt proceedings. First off, the contents of the application convince the court that there is a case for revival, and accordingly the order dated so and so whereby contempt proceedings were disposed of stands recalled and the contempt proceedings are revived. First off, ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇಲೆ ಹಾಕೊಂಡು ಕೆಳಗಿಂದ ಬರ್ತಾ ಇದ್ಬಿಟ್ಟು ಓಕೆ.
My lords, I'll file a better affidavit, my lords, but I've also not served them a copy is what I'm told. I'll serve a better
ಕೊಡ್ಬೇಕು at least. ಎರಡು ಮೂರು ಸರಿ ತನ್ಮಯ್ told you are not giving, ಯಾರು ನೀವು ಕಾಪೀಸ್ ಕೊಡಲ್ಲ ಅಪೋನೆಂಟ್. Other day, other counsel was also complaining.
Yes, yes. No, but sometimes.
Copy of the application in IA number 2 of 2024, along with better affidavit to be filed, shall be furnished to the assessee, respondent assessee. First stop. Call this matter after 2 weeks.
Yes. Because the matter, my lords, is below the monetary limit, so we'll have to go, my lords, as per the order, my lords. But the coordinate bench order, my lords. Item 30 and 32, my lords, similar order can be passed, my lords.
30
And
and
32.
32. The subject matter of these appeals is substantially similar to the one in ITA number 154 of 2020,
My lords, the. it is
heard
not-
and disposed of by a coordinate bench of this
My lords,
court-wide order dated 27/9/2024.
My lords, the questions were different, my lords, in that matter. We are saying, my lords, matters before monetary limits. So, my lords, para 5 and para 6, my lords.
So far as the monetary limit for maintaining
Yes,
the
ma'am.
appeal is concerned.
Yes, my lords.
Okay. First, next paragraph. At paragraphs
4 and 5, my lords.
4, 5 and 6, comma, the coordinate bench has observed as under, ಬೇರೆ parameter, has observed as under. First. Next, in view of the above, this appeal is also accordingly disposed of.
Yes, my lords.
These appeals also accordingly disposed of. Yes. 31.
Was delay of, my lords, 146 days, my lords.
Delay control madam brother.
Control.
ನೋಡಪ್ಪ delay control ಮಾಡಿ. ಕಾಪಿ ಕೊಟ್ಟಾರಾ? ಅದೇ.
No,
Copy
no, copy
ಕೊಡ್ಬೇಕು
is
ನೀವು.
served, my lords.
No, no.
Huh?
In the last occasion, they.
ಇನ್ನೊಂದು
told
ಕೊಡಿ.
the-
ಅವ್ರ ಕ್ಲೈಂಟ್ ಗೆ ತೋರ್ಸಕ್ ಬೇಕಾ?
I'll file, give it to my lords.
All right. I allowed.
Not.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ ಇನ್ನೊಂದು.
I'll give a copy, my lords.
Yes, next.
What's in relation to a joint development agreement where the landowners were entitled to about 200 apartments.
ಇವೆರಡು ತಗೋಬೇಕಾ?
20, yes, Lords, 21 and 33.
ಹಾ.
Lords, there is a joint development agreement in relation to 6 acres, 11 guntas of property, which was developed jointly along with another 10 acres of property, where the family of the respondents who are before your lordships was given about 200 apartments. They have sold most of the apartments. Some apartments they have retained, which they have not sold for various reasons. Lords, now they go before the consumer court saying that there is a deficiency of service. Lords, between the landowner and the landowner and the developer, if the object of giving the lands for development is commercial purpose, then
ಹಾಗಾಗಿ ಅದು ಇದರಲ್ಲಿ ಬೀಳಲ್ಲ ಅಂತನಾ?
ಬರೋದಿಲ್ಲ. Lords, may just refer to this judgment, my lords, of the Honorable Supreme Court. 19.4.
ಅದು ಕನ್ಸ್ಯೂಮರ್ ಯಾರು ತಗೊಂಡೋರಿದ್ರು ಬರ್ತಿತ್ತು ಅಂತ.
ಅವ್ರಿಗೆ ಬರುತ್ತೆ. ಅಥವಾ Lords, if this project, if the joint development is given
For himself.
for himself, not for commercial exploitation, then Consumer Protection Act applies.
Issue emergent notice, interim order as prayed for. Full stop. While issuing notice and granting reprieve, comma, we have taken note of apex court decision in Leelavati Kirtilal Mehta Medical Trust versus Unique Shanti Developers 2020 2 ACC 265.
Lords,
Call along with each other. Then office objection is there.
Respond number 2 with the managing director. The company has preferred the writ petition. Respond number 2 may not be made a party.
Lord, since in the area of parties before the
Allidang Madi.
Allidang Madidiri.
Madidiri.
Yes. That may be, we may be permitted to delete, my lords, the second.
The petitioner is permitted to disarray the disarray alla. Office objection ಪ್ರಶ್ನೆ
Managing director.
ಇಲ್ಲ disarray alla ಅವ್ರು ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದಾರೆ ಆಫೀಸ್
Because the company.
Lords, company.
may not be necessary.
Not.
Office objection as to non-arraying of a party is not sustainable. Okay.
Please, my lords, grateful.
Next. Ravi, where from you articulate the things so succinctly?
It's a learning process, a constant learning process, my lords.
ಅದು ನಮಗೂ ನಿಮ್ಗೆ ಅಷ್ಟೇ ಅಲ್ಲ ನಮಗೂ ಅದೇ ಅದು.
Please.
Yes.
Grateful, my lords.
I appeal for the petitioner, my lord.
Yes, Mohan.
Petitioner challenging appeal against the DRAT order Chennai, my lord.
You went in appeal
Yeah, yes, my lord.
before in Madras.
It was in Madras, my lord.
Ah.
The property was sold, the market value is 8 crores, my lord. They sold it for 2 crores. That too, the auction sale was held during the SOP in force of
COVID.
COVID.
Notice ತೊಳಿ ನೋಡ್.
My lord, the auction purchase is trying to alienate the property. I already paid 1 crore before DRAT, another 30 lakhs in High Court, my lord.
ಅವರು DRAT ಇವ್ರು ಏನಂತಾರೆ?
DRAT,
ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ?
the order is page number 41, my lord.
For one.
41. I have taken a main stand was that the assignment deed was not registered in Karnataka, my lord. That was one of the main ground. That was not considered by the DRAT, my lord. It is a mandatory as per Registration Act 28. It is a mandate, it has to be registered. It is not a registered assignment deed, my lord. The ARCEL.
Assignment deed is not
I
registered.
referred a judgment also, my lord.
How that's going to come to your aid? Aspect.
I referred the judgment, my lord.
No, that's registered is no judgment 17(1) perhaps E requires compulsory registration. We understand.
Yes.
How that's going to help you?
No, it was not registered. The assignment deed is not registered and as per their own assignment deed, my lord. That too, they sold it for just 2 crores. The previous auction sale notice, the reserve price was 3 crores 80 lakhs, my lord. They reduced to 2 crores.
By separate order.
Yes.
How many times auction was notified?
3 times, my lord.
3 times
Only
ಅಂತ
3
power
times.
ಇರ್ತದೆ.
No, no, within 12 months, my lord.
Correct.
Yes. Not even that they are ready, as per the IBR Act, it is only 10% is allowed.
All right. You are the debtor,
Yes, my lord.
borrower. You pay that money, everything.
I'm ready,
will be-
my lord. I'm ready to pay the payment. Already I deposited 1 crore before DRAT. Another 30 lakhs was pending in registry of High Court of Karnataka.
ಎಷ್ಟು ಅಮೌಂಟಿಗೆ ಇದು
But
ಆಗಿದೆ?
2 crores was my liabilities.
ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ಅನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿ then we'll give, that's your stand.
Already deposited.
What is that you have deposited?
1 crore before DRAT, that my total liability is 2 crores 20 lakhs, my lord.
Correct.
As per the
With
DRAT
interest
order.
ಎಷ್ಟಾಗ್ತದೆ? With interest ಎಷ್ಟಾಗ್ತದೆ? With interest ಎಷ್ಟಾಗ್ತದೆ?
Interest, if you calculate, will cross my some around 2.5 crores or something, my lord. 2.5 crores.
ಎಷ್ಟು ಅಮೌಂಟ್ ಯಾವಾಗ ಬಾರೋ ಮಾಡಿದ್ರಿ ಹೇಳಿ? What is the rate of
I
interest?
already deposited 1 crore 30 lakhs.
Which is the borrowed, how much you had borrowed? It's a matter of calculation.
Yes.
Within 10 seconds, we can do that.
I borrowed rupees to 2 crores 63 lakhs 50,000 was
All right.
out of which I already repaid 1 crores towards the loan account.
This borrowing was done when?
in the year 2015.
ಮತ್ತೆ 9 years ಆಗ್ತದೆ.
1.3 I already paid.
One second. This was 2015, 10, almost more than 9 years ago. 1 crore you paid when?
During the pendency of my, when account was active, I made a repayment of 1 crore 30 lakhs.
You pay now another crore.
Already my amount is.
Then only, if you succeed, you will get everything. Otherwise, how can we grant the interim order to you?
Yes. Or 50 lakhs I'll make payment.
No. Even according to you, so much
Yes.
more than that money is payable. Okay. Issue emergent notice. First off, the subject property shall not be alienated or encumbered by the auction buyer during the auction buyer till next date of hearing. First off, petitioner, in order to avail the benefit of this order, shall deposit with yav bank
That is Aircel.
deposit a
No,
sum
I'll
of
be
rupees 1
deposit
crore
before
in
the
the registry of
regist-
this court in 3 equalized installments of other 3 equalized installments, each of 2 weeks. Each of 2 weeks.
3 weeks.
2 weeks ನಲ್ಲಿ ಒಂದು 6 week ಕೊಟ್ಟಿವಿ ಈಗ.
Much. Much.
Correct. Seven disposal. But same ಮಗ್ಲಲ್ಲೇ ಮಾಡಿದ್ವಿ.
Serial number 16, my lords. I'm told, my lords, Jeevan Naval will take notice, my lords, that in 1/6, my lords, that Amit Deshpande matter, my lords. Yes, my lords, that Mr. Jeevan will take.
Sandeep is there.
Your Lordship, serial number 37.
37, yes. They are. Yes. No, 16, my lords, 37 is being mentioned, my lords.
Yes, sister, tell.
Yes, Your Lordship, because of some personal inconvenience, he was not here to attend the matter. Can it be posted after 2 weeks, Your Lordship?
All right. 37 ತಾನೆ?
37.
37. Call after it. ಯಾವ year ಅದು? 37.
Mr. August.
2015. Not
Yes, Your Lordship.
No time will be given.
Your Lordship, yes, Your Lordship. Finally, it can be given, Your Lordship, 2 weeks' time.
Finally, 2 weeks, finally.
Much obliged, Your Lordship.
Serial number 39, my lord.
Huh?
Serial number 39, my lord.
39.
Shankar sir has to appear in this matter. There is some bereavement in his old colleague's family. Family request for 2 week time, my lord.
39. 2 weeks on the ground of bereavement in but on 2 weeks ಅಷ್ಟಾಗಿ.
Serial number 42, madam.
42.
Much obliged.
I appear for the appellant, madam.
ನಿನ್ನೆ ನೀವು 10 ದಿವಸ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ, ನಾವೇನೋ ಹೂ ಅಂದ್ಬಿಟ್ವಿ. ಅದನ್ನ ಸ್ವಲ್ಪ ಕರ್ಟೇಲ್ ಮಾಡಿ
Please, madam.
ಒಂದು ವಾರದಲ್ಲಿ ಕೊಡಿ.
Please, definitely.
Huh?
I'll do.
Okay.
Serial number 42, madam. I appear for the.
42.
In the afternoon, there's some personal, can it be taken up next week, madam?
All right. Week after next. Aditya has to
Please.
come back from his Kumbh Mela. All right, week after next at the request of council.
Interim order may kindly be.
Interim order to continue.
Much.
38.1.
My lords, department appeal, my lords. I may be permitted to withdraw, my lords. Monetary limit.
ಬರ್ಕೊಳ್ಳಿ. ಅದೊಂದು ಮೆಮೊ ಹಾಕ್ಬಿಡಿ
Please.
Council, panel council appearing for the appellant. In 38.1.
CA 9/2019, my
The
lords.
CA 9 of 2019 has moved a memo seeking leave of the court to withdraw the appeal in view of prescribed monetary limit of rupees 2 crores. First, memo reads as under. Next one, in view of the above, appeal is disposed of as having been withdrawn. Memo reads as under.
Serial number 43.
Eh?
Serial number 43. We are not the final.
43,
Yes, ma'am.
2023.
Panel is changed, my lord.
ಏನಂತೆ
Panel is changed.
ಅವ್ರಿಲ್ಲ ಅಂತನಾ?
Yes, ma'am.
Jeevan Niralgi appears. Amit Deshpande is permitted, Amit Deshpande is permitted to retire from the case. In his stead, Mr. Jeevan Niralgi appears. Copy kodebek. The appeal papers to be handed over by Mr. Deshpande to Mr. Niralgi forthwith. Okay. Call after 2 weeks.
Much.
Right?
Date ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಹಾ, ನಾನು ಜಾಯಿಂಟ್ ವರ್ಕರ್. Date ಕೊಡ್ತಾ ಇದ್ದೀರಾ? Entry ಮಾಡಬೇಕು.
41 is your, no?
Apotex. Are you ready?
You start, I'll have to respond.
if discusses question of law, someone very beautifully writes, in fact, 5 questions arise before the courts. 1, question of fact, whether Alexander had come to India in BC 323 is question of fact. Question of law, whether X causing stab injury to Y, resulting into death of Y, amounts to murder. Okay, this is question of law. Question of discretion, whether on conviction 3 years imprisonment should be given or 7 years imprisonment should be given. Discretion, he classifies it as questions of discretion. Then questions of opinion, whether another person like Alexander would come to India in 2047. It's an opinion. Okay, 4, he does it. Some Scandinavian countries have made 5, may not be relevant in Indian jurisdiction at all. Further, Salmond says in his 12th edition, Fitzgerald's edition, if answer to a question is to be found in the statute book, it's a question of law. If answer to a question to be found from the record of evidence, then it's a question of fact. In the light of this, some judgments under Income Tax Act, because substantial question of law, under section 100 of CPC, substantial question of section 30 of Employees Compensation Act, substantial questions of. Yours is question of.
Yes.
What is the question of law?
Lords, my humble submission is, my lords, there has been no appreciation of evidence by the NCLT, by the company law board. My humble submission is, in fact, the matter was remanded back for
That's
the.
not it, you have said that.
So,
Don't
my lords,
repeat.
my humble submission is, my lords,
No, we're asking you whether a question relating to appreciation of evidence, is it a question of law or question of fact? How courts have held?
my lords, appreciation of, my lords, improper appreciation of evidence
Is also question of law.
would amount to a question of law. My lords, given the fact that it would impinge on a point of law. So such being the case, my lords, and here is the situation where matter has been remanded back to the company law board for the purpose of recording evidence. Evidence is recorded. The evidence is not even looked into. There are 4 aspects which are considered by the tribunal factually. Whether the petitioners are to be reinstated as directors. They have been removed, they are to be reinstated. In the first place, they were not removed, my lords. They have vacated the office as directors. It is not appreciated. Legally, it is not appreciated.
They have vacated the office.
They have been
removed.
They were not
from
removed
office.
They were not removed from the office as directors. On the face of it, my lords, it is a factual non-appreciation. My lords, the second aspect is, my lords, with respect to the lands being sold, there is a finding that it is a fraud. We have not conducted things fairly. My lords, my humble submission is board meeting was held. My lords, the petitioners were present in those board meetings. And my lords,
Where is the question of law you have framed in the appeal? Because appeal is only on question of law, not otherwise. Where have you framed the question of law? A. Ramaya on Companies Act summary.
my lords, page 7 of the appeal, my lords.
Page 7 of appeal memo.
Appeal memorandum of appeal. Questions at para 8 minutes.
if I may quote. For 8 minutes.
Very happily coined questions. What are the incidents of oppression?
Lords, the allegations are, my lords, the property was sold very unfairly at an advantage which the appellants have made benefit out of.
Where is the idea of oppression enacted in which provision?
My lords, 397, my lords. If I may quote. My lords. Lords, if I may submit, it is 241 under the 2013 Act, my lords.
Let us see 397 itself.
397, yes. I quote, my lords. Application to tribunal for relief in case of oppression. Any members of the company who complain that the affairs of the company are being conducted in a manner prejudicial to public interest or in a manner oppressive to any member or members, including any one or more of themselves, may apply to the tribunal for an order under this section, provided such members have a right to so apply in virtue of section 399. 2, subsection 2. If on any application under subsection 1, the tribunal is of opinion A, that the company's affairs are being conducted in a manner prejudicial to public interest or in a manner oppressive to any member or members, and B, that to wind up the company would unfairly prejudice such member or members, but that otherwise the facts would justify the making of a winding up order on the ground that it was just and equitable that the company should be wound up. The tribunal may, with a view to bringing to an end the matters complained of, make such order as it thinks fit. I quote section 398. 398.
Why 98?
398 is mismanagement.
Where is the mismanagement here?
Uh,
Section 397 incorporates 399. Bunny. He started.
Sorry,
No
I
issue.
thought I held up in another
That's
question.
very good. No issue, no issue.
The minority and oppression of mismanagement, oppression of minority and mismanagement, they are, my lord, traditionally under one heading in the old Companies Act of 1956, which is repeated now in the new Act of 2013. The precursor to this is the 1948 English Companies Act. And that was the first action. Old section 210 in the 48 Act is practically exactly a repetition of what is there in the 56 Indian Act. That same law has now been seen in section 240 to 41 in the latest 2013 Act. So it has been the same. My lord, in the case of any company, my lord, where there are two groups of shareholders or minority shareholders, there is a provision, my lord, under section 433.
How to decide who is a minority shareholder?
That is in terms of the shareholding. The Act
Percentage.
itself says that if it is a company which has share capital, then a person who holds 1/10 of the share capital or 1/10 of the number of shareholders of the company. Suppose it has 100 shareholders,
Then
then
10%.
10 should come. Supposing company has
In
1
terms
lakh,
of, shareholding, shareholders 10%.
number of shareholders 1/10, or 1/10 of the share capital holders of shares. The act itself defines that as section 319.
It's also defined.
Yes, it says this is the minority for the purpose of this protection. Now this.
How many members of
In this case,
Yeah.
the total number of paid up shares, my lord, are 52,650. Out of that, these two petitioners together hold 5,300 shares. So they qualify.
petitioners hold?
5,000, 5,300 shares together. Each holds 2,650 shares. There are two petitioners who are respondents 2 and 3 before your lordships in this appeal. Respondent 2 and 3 were the original petitioners. Each of them holds 2,650 shares.
So that will be 5,000.
5,300, which is slightly more than 10% of 52,650. Total share capital.
Minority only.
They are minority, my lord, because minority is somebody who holds more than 10%. Below 10%, you have no right to come because there's a special procedure for that.
Okay, which is that 299?
Yes, ma'am. 399.
399.
The following members of a company shall have the right to apply under sections 397, 398. A, in the case of a company having a share capital not less than 100 members of the company, or not less than 1/10 of the total number of its members, whichever is less, or any member or members holding not less than 1/10 of the issued share.
Not less than 1/10.
Yes.
So this is more than 1/10.
Yes. If they don't hold 1/10,
They will
or
not
they
be
don't have,
entitled to apply at all.
then they can't apply. There is a provision, my lord, for a dispensation and in subsection 4.
Even when that does not.
Yes, ma'am. The central government may, if in its opinion, circumstances exist which make it just and equitable to do so, authorize
They
any
permit
member or
them to
member.
apply 396.
Even if they don't hold the qualification shares, you can approach the central government and they can
So
give
that
that.
condition is relaxable at the discretion of the central government. But that question will not arise because they are already
Exactly.
within the parameters.
They're already above the threshold.
What is the operation? This is a case of operation, not mismanagement.
They allege both, my lord.
Both.
Yes. Both
Where are they state?
Yes.
Just show them.
The petition, my lord, is available in the, there are, I think, more than one volume. Your lordships may take.
And there are just on the 2 lines ತೋರಿಸಿ.
Yes, yes.
Mismanagement ಇದೆ, operation ಇದೆ ಅಂತ. ಎಲ್ಲಿ ನೀವು ಹೇಳಿರಿ ಅಂತ ತೋರಿಸಿ.
Not at volume number 2. And appeal one petition. I'm sorry, bro. The petition is volume number 1.
Volume 1.
Yes.
But
page 1.
Volume 1 ಕೊಡಿ.
The averments, my lord, relating to
ಇದೇ ಒನ್ನ. Page number.
The averments, my lord, relating to the facts, etc. start at page 7, but there's summary, my lord, what they say here.
Operation ಆಗಿದೆ, mismanagement ಆಗಿದೆ. These are the sine qua non. ಅದೆಲ್ಲಿದೆ?
ಆ ತರ what they've done is ಒಂಥರ narration ಅಲ್ಲಿ ಹೇಳ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಏನೇನ್ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ. So they have not put it under particular headings. If your lordships would see page 8.
But
the main grievance
section
not-
is very, very specific.
Correct, correct. They must, they ought to have, my lord, said the following.
The acts amount to our oppression.
Following.
These acts amount to mismanagement.
Yes.
ಆ ರೀತಿ ಅവർಮೆಂಟ್ ಬೇಕಲ್ಲ?
ಆ ತರ ಇಲ್ಲ. That's not how they have proceeded with. The main allegation, my lord, is this, that this company, this, my lord, the object of this company was to do some real estate development. So, my lord, the company purchased some lands in Badrahalli near Nelamangala. 2 pieces of land it purchased. Totally, my lord, 9 acres and 7 guntas. Now,
What is the law on the point? Even in the absence of such pleadings, whether 397 is invocable? That's Ramaya Tarsil.
Adralli,
Ramaya Tarsil, section 3,
if the
96, 97 in the Irvantha.
if on a conspectus and reading of the petition, if an act of oppression can be made out, the courts have normally taken that view, my lord, without specifically insisting.
Words in Bekil.
Atara express agi, ide act of mismanagement, ide act of oppression, you need not particularize. But in this narration, what can one gather is their main grievance is that this land, which was bought in the name of the company, was sold away for a song by some of the directors. So this has affected me. And some part of this land was purchased by one relative of one director.
Only in the kindly read 397.
Yes.
Wording is bit different. Any member of a company.
Any members of a company
Who complains that
complain
the affairs of the company are being conducted in a manner
prejudicial
prejudicial to public interest
or in a manner oppressive to any member or members, including any one or more of themselves.
Therefore, public interest affect agbeku. Ivaru ಮಾಡ್ತಾ ಇರೋದು. I do not know. I am just reading. My knowledge on this is very, very frugal. I confess that to you. Public interest ಏನು affect ಆಗಿದೆ ಅಂತ ಎಲ್ಲರೂ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅರ ಬೇಕಲ್ಲ. ಇದರಿಂದ ಈ ಆಕ್ಟ್ಸ್ ಗಳು ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಪೆಟ್ಟಾಗ್ತದೆ.
ಅದೇ ಇಲ್ಲಿ ಆರ್ ಅನ್ನೋದಕ್ಕೆ the interpretation is it may if there are different compartments, my lord. If affairs are being conducted in a manner prejudicial to public interest, if I stop there for one moment.
Correct.
Supposing this company is manufacturing bombs for Pakistan and they are exporting it there.
That's a prejudicial
Then, my lord,
public interest.
it will be very clear that this is an act which is prejudicial to public interest.
Correct.
No, it
But
is not.
I appreciate your example.
Sorry, man, I'm just
Because
thinking of
such things, these examples also sometimes, though offhand we quote those examples in certain forums, at times they may be true also.
Correct. This is one category. Now, there is no such issue. But what they're doing, another example I'll give, not. Supposing there's a company, the company is supposed to issue shares to all the members. Whenever it issues shares, it must make an offer, ask other shareholders, do you want to buy? If you don't want to buy, we'll issue to others. They don't ask, but they issue shares to themselves, directors.
Whether public interest is defined here anywhere?
No, not defined.
Not defined. Whether any leading judgment which interpret this provision? Can you
My lord,
quote?
most of the cases which have come before courts, from 1956 onward, my lord, first judgment which came before Supreme Court under the old Act of 1913 was the Rajmundry Electric case, 1956.
Famous judgment.
Yeah. So there also, my lord, the issue was not on public interest, it was on private dispute. So 397 essentially has become a kind of a equitable partition type of provision.
Same sentence Mr. Aditya said when your friend stood up and said. Okay.
First, the operation mismanagement that I did, I learned from senior, I was with my then senior Mr. Raghavan, and he were opposing each other in a famous case called Ultra Filter. So I had the opportunity to learn from senior in Ultra Filter's case.
We have opportunity to learn from him even today. We have learned so much from him. He's the way he argues, especially in that hijab judgment and other things. Very, very, really, Mr. Naganandu, I should tell you, the way you conducted that hijab judgment, the case, it was unique. Sometimes I see in online, I replay them and see them so beautifully and very persuasively you had argued that matter.
The court is not receptive. We get little more enthusiasm. Sometimes what happens, the court is somewhat, looks disinterested. Not it is, but
It looks that way.
in such a situation, my lord, there's no provocation for us to argue the matter in the manner in which we should develop. Especially, my lord, in constitutional litigation, that's what we find. The more there is a, my lord, in fact, I remember Justice Venkatachalaya's court, my lord. Every time you appeared before that court, you would go with the feeling that the court is looking at one point which never occurred to me.
Okay.
And I remember, my lord, number of cases which I argued. At the end of hearing, after 10 days, you'll say, you know, there is one sentence on this point in Palmer and Company law. You say there's a discretion to wind up a company. So what is that discretion? How do you exercise that discretion? It says the company may be wound up. May means what? Just see, there's a discussion. There are two authors which dealt with that. So when that point is given to us, though I had read it and I was presenting the case, but when that particular point was made, I went and searched. And I find, my lord, one exact passage, both in Palmer and Buckley Company law, where they both deal with this issue as to how the court should exercise its discretion, whether to wind up or not to wind up, in a case where a case is made out that the company is insolvent. Even if the company is insolvent, when the law says may,
still you have discretion not to wind
the
up.
court can say, it is insolvent, but I don't exercise my discretion. To suit that, what are the guidelines? So there are guidelines for that. So like that, my lord, when the court is, my lord,
he is a stalwart.
Absolutely.
That's that much we can say. Incidentally, since you mentioned May, in one judgment, Lord Halsbury said, discretion means in accordance with the rules of reason and justice. So beautifully he has written it. I don't remember the name of the case. Very beautifully he has written. One. Number two, Cardozo in his judicial process discusses the Benjamin Nathan.
Yes, yes, I think.
Discretion is not of Mughal discretion. Discretion is to choose one of multiple principles in the given set of facts. And that choice also should not be arbitrary.
Exactly.
This is how he deals. Venkatachalaya is another. Where have you sent all such judges? Where have they gone? We should ask ourselves no. Great judge. Yes,
the learning, my lord, that in fact, when many times, my lord, some youngsters come as interns and others. So I ask them, you're in 4th year or 5th year, which textbooks you have read? Said instead of, going to court, sitting there doing nothing, and during your academic time, you please ask your professors for each subject on this semester, which is the leading textbook on the subject which I'm learning. You ask them before the semester begins. Then in the break, you have to take that book and you have to read it from top to bottom, only for the purpose of gaining knowledge which is there in it, not for any other purpose. That's the only way in which you can learn the subject and you will master the subject, because once you learn it, it is going to be of use to you throughout your life. At some stage, when you're looking at a particular provision which is to deal with this, that will come to your mind to say, there's such and such.
You will be arguing.
Go and research in that, you will find an answer in that. If they don't read it, my lord,
no, unfortunately, I should tell this. Reading habit in the masses, amongst the masses, is very, very, it's going down very steeply. There is no such thing. Many books I quote so that they will be knowing at least these books are there.
Exactly.
Even that they do not make note of. When your father, great Sundar Swami, used to argue, we used to sit in the court hall. And every note, you may not believe, my index to my notes, they run into 4 volumes. Many I had taken from great Sundar Swami. The way they used to argue, no style, nothing, etc., only substance. That is not happening in the court halls. we don't feel like hearing the argument or reading two sections as if treating that case as a one arising under the Cattle Trespass Act, going away.
Correct.
That kind of attitude, how they will be able to do justice to the clients?
No, also, my lord, I think the.
Of course,
sheer
justice also should be
pressure.
very receptive. Pressure, all right.
Pressure of work, my lord, the number of cases that the courts have to deal with, it's so stupendous.
For us, that is a ground. For
Yes.
you, it is not.
No, I'm only referring to the honorable courts, my lord, because. the
Because we
courts are
work
so
under
much
tremendous
overburdened.
pressure. So many cases we have to, still we have to read, that's another thing. But for youngsters, why are they not reading? They will not be knowing which are the famous judgments of our Supreme Court, which are the dissenting judgments of Oliver Wendell Holmes, which are the dissenting judgments of International Court of Justice. These things, which is the best international law, J.G. Stark, Oppenheim, Rebecca, they will not be Brownlee. They will not be able to tell the names of the authors also. Best books on Contract Act, Cheshire Foot, Permston, Chitty, Anson. They will not be able to quote these books also, authors. We are not saying you should turn pages of every book. It's impossible. But at least
I tell my colleagues in the office, my lord, the young ones, to say, before you do anything, first go around the entire office and see which books are there.
Correct.
Which are the textbooks that are available, which are the commentaries that are there, where are they placed? Even if you don't know that, how will you ask the librarian to get you a book?
Unless you know.
You know that there's no such book at all. Is it there or no? And where it is, she will help you. But you must know what is where. That such a book is there.
In one Upanishad, there is one shloka, Astiti Chedveda, Santamenam Tato Viduhu, Modalu Ideyandu Tili, Nantara Iddadannu
Taittiriya Upanishad.
Taittiriya Upanishad.
Santamenam Nato Viduhu.
Correct. Nowadays, you people do not like knowledge and knowledgeable people. That is another thing. Anyway, things are going that way. Let them go. Yes, sir.
No, my lord, the
So your first
section-
submission is, in so many words, you need not say that it is prejudicial to public interest.
Yeah.
Nor it is necessary to say that I have been meted with minority oppression. Need not be. That should be gathered from the pleadings of the
Pleadings.
parties.
That seems to be-
gather ಮಾಡ್ಲಿಕ್ಕೆ ಬೇಕಾಗೋ
ಅದು ಬೇಕಾಗುತ್ತೆ.
ಆ ಕಂಟೆನ್ಷನ್ಸ್ ಎಲ್ಲಿದೆ ಎವರ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ
Government-ಗೆ ಅದೇನೆ. What has happened, my lord, very dispersed kind of argument. They have taken, my lord, bits and pieces here and there. They did this is wrong. They did this is illegal. They did this contrary to law. And one more principle, my lord, which courts have consistently approved when it comes to 397 powers is, courts have said, whether an action is legal or illegal is not an issue for grant of relief under 397. An action may be perfectly legal, but it may still be oppressive. And the converse, an action
Also
may be illegal, but it may not be
need
oppressive.
oppressive.
So there's a famous statement, my lord, of Justice Bhagwati in 65 in the Gujarat High Court, which has later been affirmed by the Supreme Court, my lord, in number of cases, where the judgment, the oppression, allegation of oppression, it is not sufficient if you just say that this is an illegal act, therefore grant me relief.
It should result into oppression as such.
This is one aspect. Second aspect, my lord, is the section itself, and this is interpreted in that manner. The courts have laid down that the relief against oppression and mismanagement is alternative to the relief of winding up. Because under winding
Otherwise, eventually it would have gone for winding.
correct, under
To
just
avoid
and
that,
equitable
this is-
clause. If your lordship sees section 433 F,
Like it's that which pressure cooker will have that exit tag that way.
433 says, in what circumstances a company can be wound up. A company may be wound up by the then court down tribunal if it has passed a special resolution, default in delivering statutory report, does not commence business, number of members reduced to below 2, unable to pay its debts. This is one which is most often used. And F, this is also important. This is just and equitable clause. If the court is of the opinion that it is just and equitable, that the company should be wound up. Now, that means this is a foundational averment and a fact which you should establish. You should say this company is just and equitable to wind it up. Why it is so? Just and equitable has been subject to interpretation, and there are classifications where the court will come to the conclusion it's just and equitable. One classic case is of deadlock. Supposing a company has 50-50%, two shareholders. They're not able to agree on anything. If one person says we'll do this, other person says we won't do this. So there's a deadlock, company can't go. So that is one classic case of a deadlock situation where just and equitable applies. The second category is supposing the business of the company becomes illegal. In the case of enemy country. Now you are doing some activity in connection with some enemy country, which is declared to be an enemy country. So in that case, you can't continue that business. Or if some business, my lord, is declared to be illegal, let us say. For example, in one state,
Tobacco companies
they
earlier.
complete prohibition. So no liquor at all can be produced in the state, if they say. And that's the only business of the company.
Although that will never happen.
Looks unlikely. No, because they're getting so much money from that. So it's not possible to conceive of that situation.
Correct.
Though in
So
Gujarat, it is still there on paper. In Gujarat, prohibition is still in operation. But they tell me maximum amount of liquor is consumed in Gujarat compared to neighboring states.
That's true.
There are always ways and means. So this just and equitable, my lord, is interpreted in a certain manner. So the first requisite is that the petitioner who comes to court must make an averment that here is a company, the manner in which it is conducted its affairs, it is just and equitable to wind up this company. But please don't wind it up.
Go for less.
If you wind it up, it's going to prejudicially affect me. So please grant me this other relief. What is that other relief? Relief which you can grant under 397, 398, 402, 403. Those powers are available to you. For example, my lord, supposing they say that a company has entered into an agreement with somebody to sell all its produce at 50% of the cost price. A minority shareholder can come and say, look here, I am a shareholder here. This majority shareholders in the board, they passed a resolution. This company will be perpetually in loss. Therefore, this is an obnoxious agreement. It cannot be permitted to stand. So please don't wind up this company. You just annul that agreement. Terminate that agreement. So that is one of the reliefs which can be granted.
Whether they also will be parties to such proceedings?
The section requires that if the agreement is with a third party, the decision to annul that will only be taken after notice and hearing. If it is internally within shareholders, the court can do it. But if any external party is involved in an agreement, like in the illustration I was giving, supposing to some XYZ, 50% produce is to be sold at 50% of the cost, then notice should go to them to annul this. I remember one case, one very old case which came up here. This is a dispute between a brother and sister. The sister was owning about 20% shares, brother held the rest. The brother entered into an agreement with a developer. It's a famous Raheja building lot on MG Road. The company belonged to an Anglo-Indian family, brother and sister. So the sister filed the case, and the sister's contention was, these people have entered into an agreement with this builder. This agreement is not a fair agreement. And the company should have got more money. Company valuable property is there. And also there's some allegations about something else were also made. For collateral reasons this was done. And in the petition, my lord, we sought a prayer to annul that agreement on the ground that it is not in the interest of the company. The learned judge, senior justice Bopanna, my lord, granted an interim order to say, don't take further steps in the matter. And thereafter, my lord, the matter went on for some time. It went up in appeal against that order up to Supreme Court, confirmed. Thereafter, my lord, parties sat down. Mr. G.P. Shivprakash, then Justice G.P. Shivprakash was the lawyer on the other side. We all sat down, my lord, and tried to resolve it. And brother and sister agreed for a settlement. And we reported settlement to the court. And we said we are not pressing that prayer. And the sister share, whatever is to be given, was agreed to be given to her. She received the money and the petition was closed in terms of a compromise. So why I am submitting, my lord, is that it is possible to seek such a relief, to say that you annul the sale. Now, one of the prayers in this is that the company has sold some of its assets. That sale was not fair and proper. So you annul that sale, or you direct the remaining shareholders to bring in market value of the sale value. If it's sold for 100 rupees, but if the market value is 200, you direct that they should pay them 200, 100 rupees back to the company. Such an order was made. And there's an interim order granted.
The scope appears to be very wide.
Very wide, my lord. It's very wide and it's equitable in nature. And in the recent trend, my lord, again, starting from 1981, when that leading judgment, my lord, of Needle Industries came up for the Supreme Court, this 397, the scope has been further widened by a series of decisions, my lord. The question has arisen, supposing the petitioner does not make out a case of operation and mismanagement. There is a deadlock in the company. He has still not been able to make out a case that something was wrong. Everything was done legally, lawfully. What should be done with the petition? Should we dismiss it? Or should the court step in and ask, both of you are quarreling like this, why not one of you go away? You exit the company. You take the value of the company, we'll get it valued. And once it's valued, we'll decide as to who should go out, who should stay. And each will pay the other outgoing shareholder. So the outgoing shareholder will get his real value of the company. So what more is to be done? So this is a more
Kind of very like the English equitable courts.
Exactly, court of equity. So that seems to be the recent trend where courts have taken the view that strictly one need not go by the government on both on lawfulness, unlawfulness, and on the question of this just and equitable nature. Whether you should actually prove it, you should plead it. In fact, in that brother-sister case, I remember Mr. G. Ramsamy was appearing against us. First point he raised was that. He said this small domestic company is there. There's no allegation, no averment that this is liable to be wound up because there is majority shareholder, there's minority shareholder. Company is running properly. It has balance sheet, audit, it's doing business. The sale has taken place. We'll justify the sale. Why should you entertain a petition? There's no need because company, there are mechanisms within the company. If supposing I think some director is not doing what he's supposed to do, I can call for a meeting to remove him. If I have shareholding percentage, then that resolution will be passed. If I don't have shareholding percentage, it will not be passed. So whoever is majority shareholder, corporate democracy will prevail and that person will be in power. So this tempering of that power, my lord, is what we see in 397. Because those are absolute powers. And whether court of equity should step in to give some semblance of fairness and equity in treatment is what courts have not looked at when exercising power under 397. So generally, my lord, the courts do not insist on exact wording to be there. But this severment is necessary because unless it is proved,
So that appears to be that.
it's the starting point. My lord, and also one more principle is that the principles which apply to corporate democracy in a large company, where there are thousands and millions of shareholders, not of listed companies, we have so many of them which has 1 million, 2 million shareholders. The principles of 397 apply to them also. But when it comes to a small domestic company, then the law has fashioned a term called quasi-partnership. Now, a quasi-partnership is, this is not a partnership in law, it is a company only. But
like quasi-contract.
Exactly. It is not a contract, but looks like a contract. Same way, this is not a partnership, but the principles of partnership law can be extended to such companies. So when you extend it to such companies, then this act of mutual good faith,
these things,
all of the other things about right to run the company together. Suppose it's a company with, say, 4 directors, 2 are whole-time directors. Now, if one whole-time director has got 25% shares, other 3 people come together and remove him. The company can say, I have removed him, therefore,
majority.
There, this quasi-partnership comes in, where court, the 397 court, my lord, will look into it and say, is this fair? Is this burdensome? Is this harsh?
That's
These
the
three expressions are, my lord, used in the context of 397. It was coined, my lord, by Lord Wilberforce in the first judgment, my lord, which dealt with it to some depth, is Ibrahimi versus Westbourne Galleries. That's, my lord, referred
Just
to.
give leading judgments.
Yes.
We will read and come back.
Yes, my lord.
Yeah.
The,
You give the
may I,
judgments only, that will be a great help to us.
if your lordship permits, my lord, I'll make a small compilation, give it.
That's all. That because of course, now we understood how section is coined. What's the underlying philosophy of that section? That way. In fact, the parliament has enacted equity into this section itself.
Exactly. And courts have interpreted it in that manner
That way.
also, my lord. Courts have said that though there is the strict rule, because in the earliest case, my lord, of 1965 Supreme Court, where Shanti Prasad Jain's case, one of the early cases which came to
Shanti
Supreme
Lal
Court.
Jain?
No,
Kalinga
Shanti
Prasad
Prasad Jain versus Kalinga Tubes.
Kalinga Tubes.
That is the earliest 65 Supreme Court, 1535, my lord, if my memory is right.
Yes, yes.
That must be the earliest case which went under the 56 Act up to Supreme Court, where they dealt with this question about whether these allegations should continue.
Different case, perhaps.
Pardon, my lord?
There is another case, State of Bihar versus Kalinga Tubes.
That's
That's
a different-
another. Okay.
Kalinga Tubes again. So in that case, what happened was, the point that arose was, there was some act of oppression relating to some share issue. And the minority shareholder challenged it on the ground that this is a oppressive act. They've taken away my right to shares. The argument against it was that this is a sole one incident. So for this one incident, how can you file a petition under 397? Because the section says affairs of the company are being conducted. So
Suppose if one drastic incident happens, then that will be out of section 397.
So, no, the court dealt with that also, my lord. The court said, are being conducted means it should be a series of events, or it can be one event which has a perpetual effect on the company. Supposing, my lord, a company, it had a mining company, it had one mining lease of say 500 acres. Suddenly one fine day, the managing director transfers his mining lease to somebody.
What else is required?
Then nothing more remains in the company. This is the sole instance, only incident that has happened. And therefore, this incident by itself would be a ground.
Sufficient, it can
Yes,
be.
but provided that it has this lasting.
That, in other words, the potential damage or prejudice to the company, the potential damage or actual damage may be occasioned by one single incident itself. Like there are shairis which हजारों फूल कम है एक दुल्हन को सजाने, एक गम काफी है जिंदगी भर तड़पाने. Like that one incident may be sufficient. Yeah, there perhaps so we can't borrow what Shakespeare said, one swallow makes not the summer. That may not be applicable in matters like
Correct. One swallow may have a perpetual effect.
That's
here.
what.
So the courts have had to grapple with this language and not laid down that though the language says are being conducted, if generally it is. My learned friend says my page number was correct. 65 Supreme Court, 1535. I got a doubt.
We appreciate your memory and the breadth of your reading, etc. Really, we have seen you. In fact, in one matter where you faced Mr. Fali Nariman and succeeded against him.
An appeal,
OS. So beautifully you had countered him that day. I was present in the court hall.
He had great affection for me. I can also mention that he was my client in one matter.
Oh.
He bought a flat in Bangalore. It was developed by one of his family friends. He's a Parsi gentleman. So they were our office clients. So after the building was built, then it had to be registered. So I acted for him for the registration purpose.
Okay.
Thereafter, there was a proceeding for undervaluation.
Oh.
On the ground that the duty was paid only on the land value, not on the building, which was a built-up building. So those days there was a confusion on that. So in those proceedings also I appeared. Was finally not.
These books are also, Mr. Nagananda. I should tell
Absolutely.
that, before the memory fades, you must know your constitution, the state of the nation. Can we save the judiciary, Indian judiciary? What kind of books is?
Absolutely.
Great works.
Thought provoking and
Thought provoking. Thought provoking. Aditya was saying something.
One, your lordships were mentioning a single act or a continuous act. The under 398, when it comes to mismanagement, your lordship said whether it has an effect or it has a potential effect. In 398, what the legislature does in 398B includes a very interesting language that a material change, not being a change brought about by or in the interest of creditors, debenture holders, etc., whether by alteration of board of directors or manager or in the ownership of the company's shares, or if it has no capital in its membership or in any other manner whatsoever, and by that reason or change, it is likely that the affairs of the company will be conducted in a manner prejudicial. So even the mere likelihood
Potentially
of prejudice,
sufficient.
potentially
Actually is not
Yes.
necessary.
not under 397, under 398, by virtue of a change. A triggered change brings even the potential of damage is sufficient.
No, that apart, which he said, suppose if 500 acres of mining lease,
Yes.
one fine day, by one single act, that's sufficient. Need not be so many sale deeds at all. One sale deed is sufficient to sell all that. What will happen to the company? Yes.
No, my lord, 398, though the heading says mismanagement, but this is always very intriguing, my lord. Because the section, if you read, it doesn't actually talk of what is act of mismanagement. The heading, my lord, says, this heading is application for relief in cases of mismanagement. Now, mismanagement, we must infer from the clauses A and B. A
No,
is,
that is heading of the chapter
no, application to tribunal for
for
relief.
relief in cases
Yes,
of oppression.
That
Even
is
mismanagement is also not there.
next one, my lord. This is, your lordships are reading the heading above 397.
Correct.
Please now see the heading above 398.
398.
Normally,
You are
one
right.
would have expected mismanagement definition. But here, we can only understand what it means by reading A and B. It says, any members of a company who complain that the affairs of the company are being conducted in a manner prejudicial to interest or in manner prejudicial to interest of the company. Let's stop them. So if I complain that affairs of the company are being conducted in a manner prejudicial to public interest, they're indulging in illegal things. They're indulging in tax evasion. They are doing illegal business. All these are against public interest. That could be one category to show that it comes under the category of mismanagement. Then the second portion, or in a manner prejudicial to the interests of the company. Like in that example, 500 acres of mining lease, one
Telling
day
that.
just part with it, don't receive any consideration. So
399, 390, sorry, 397 and 398 are different terminology.
different.
Yours is under 397.
No, this, they have invoked both.
Both they have invoked.
They have invoked.
No, only they have written section 397, 98, or they have taken up pleadings to fit into these parameters.
That's why I said the pleadings are left much to be desired. So it's not in that precise manner.
Yes.
Then the second part of 398, my lord, is first is prejudicial.
Correct.
Second is a material change, not being a change brought about by or in the interests of any creditors, including debenture holders or class of shareholders of the company, has taken place in the management or control of the company, whether by an alteration in its board of directors, manager, or in the ownership of the company shares, or if it has no share capital in its membership, or in any other manner whatsoever, and that by reason of such change, it is likely that the affairs of the company will be conducted in a manner prejudicial to public interest or a manner prejudicial interest to the company. So this has two portions. One is material change.
Correct.
What is that material change? Management, control, board, or ownership, shares.
Correct.
If these four happen, then the effect of that change is likely to affect.
Twin test it is.
Yes. Public interest or prejudicial interest of the company. In the
Not only
example-
these things, it should result into the second part also.
Exactly. So both these have to be satisfied. Now, in this case, the sale of a piece of property which belonged to the company, there is justification why it was done. I'll take your lordship through facts little later, my lord. When the company bought the land, what was the price at which they bought it, how long they waited, they had borrowed money, they could not repay that money, they could not start the work. Of course, my lord, we are not now, my lord, in the realm of early 2000s. Now we are in 2024. If you say now Nelamangala, then people will know what the price there is. So those days, they could not get anybody to invest money to develop that property. So they held on, and then sold. And there is evidence to show at what price it was sold. So one of the main allegations is that the sale which you made is something which is not in the interest of the company. And therefore, please give me relief. But the second and third limb of this B, whether that is satisfied, there was no change in shareholding, directorship, share capital, nothing.
Perhaps in any other manner whatsoever it may fit into.
Yeah.
There is one
Yes,
residuary
or in
clause.
any other manner. Yes.
Provided, no, it is not in the interest of the company. The language employed is in a manner prejudicial to the interest of the company. There are two different concepts.
Yes, yes, ma'am.
It may not be in the interest of the company. That is insufficient. It should be prejudicial to the interest of the company.
Now,
That's the
company has borrowings. It has not repaid monies. It has not developed the property. It has held the property for 10, 15 years. Then a board meets, board takes a decision that, we can't hold this any longer. Let us, dispose it off. They are present in those meetings. Thereafter, the discussion proceeds further. And then finally they decide now, we can't hold this any longer. Whoever is available to buy it, we sell it.
We want to sell it. It may be in the interest of the company itself.
Exactly.
We do not know. But anyway, how it virtually takes this court to the boardroom of the company.
Exactly. It would, because your lordships will have to examine now on the date on which these decisions were made.
Happened.
Was this a decision which could be characterized as an act which was a deliberate act to prejudice the interest of the company? Or was it an act in the best interest of the company? The other day.
Or it was an act which was not in the best interest of the company. That is not sufficient.
Exactly.
What is required is whether that act is prejudicial to interest of the company itself. So it's the degree of the prejudice. When we say it is not in the interest of the company, there also little prejudice is there. Difference is in degrees. Whether it is prejudicial to the interest of the company, the degree of prejudice is marked by its enormity. Such things are required, perhaps.
No, merely because, and supposing not another extreme, supposing they did not pass a proper board resolution and they decided to sell the property. Let us assume for the sake of argument that this was not legally done as required by law. Then would the court interfere only because this procedure you didn't follow?
May not.
Or will the court say, all right, you didn't follow the procedure?
But
Okay.
prejudice is a case.
Please show what has happened.
Correct.
How this is prejudicially affected.
Whether it has followed, not followed is a matter of the procedure. It may be illegal also. That is not the focal point of the section. The focal point of this section is the prejudice, perhaps little enormous prejudice, considerable prejudice we can say.
Exactly.
Considerable prejudice appears to be the focal point of Parliament.
Then, my lord, one more facet which has engaged the attention of the courts is a person who comes to court in writ jurisdiction, your lordship see it, my lord. If that person's conduct is not good, if He's not come to court with candor. He doesn't disclose facts correctly. He makes false statements in the case. Even if he has an invincible case, the court will say, we are not going to look into your case, we are going to dismiss it. In 397 jurisdiction, that is also the contours of exercise of power. In fact, my lord, no less than the former Maharaja of Mysore, in a proceeding, my lord, before this honorable court, Srikandadatta Narasimha Vadayar, he had entered into a contract with a company called Venkateshwara Real Estate Enterprises, agreeing to dispose of some part of the Bangalore Palace. And there was litigation relating to that. In that Venkateshwara Enterprises case, the Maharaja had a shareholding also. So he made allegations and came to court for relief against oppression and mismanagement. The respondent company pointed out that this petition is full of lies. He has not disclosed past agreements, amounts received, possession given, the partition and other documents that were all entered into, how much money this company has given to him, and how he has reaped benefit from the affairs of this company being a shareholder, and he is coming for oppression. Only on that ground, my lord, the learned single judge, Justice Bopanna, dismissed the petition, reported judgment. Saying
so
that
conduct of the party also
is a fact.
Will be relevant.
Very relevant factor for the court to consider whether we should give him relief, because it's equitable relief. It's not brown note relief. Brown note is there, whatever the conduct of the plaintiff doesn't matter. If so long as a document is proved and consideration is proved, not paid, you have to deliver, whether he's a good man or bad man. That's law. But when you come to equity, that's distinction, my lord, that is there. In this case, one of the points which
like R.D. Shetty.
Yes.
In R.D. Shetty,
Yes.
though so many questions were decided, they did not give relief to R.D. Shetty at all.
Exactly.
Because of the conduct.
So that those principles have now been, my lord, well accepted in this jurisdiction also. One must examine what is the nature of the allegation, what was the role played by the
So-called
petitioner.
oppressing members.
Yeah. The one who is oppressed, who's come to court, how did he conduct himself? So that is the test, the twin test, that is, conduct should be unfair, harsh,
And
burdensome from the point of view of the respondents. And on the other side, he must come to court with clean hands and with candor and disclosing all facts, invoking the equity jurisdiction of the court. So both these have to be balanced. In this case, there are a number of facts, my lord, relating to suppression of material facts. They were parties to a board meeting. They attended the board meeting where this decision to sell was taken. They are saying the minutes. Minutes were circulated also. Some time later, that decision was given effect to. Same thing with shareholding also. One of the complaints is that you allotted shares to somebody. Offer was given to everybody. They were present at that meeting and they did not choose to subscribe to those shares. That's a matter of evidence. So all this, they give it the impression that, oh, I don't know anything. How did the sale take place? And at a point of time, my lord, when there was nobody willing to buy this land, if one of the directors says, all right, I will get
Find
from one of
someone
my
who will buy
relatives, somebody who is willing to put his money, hard-earned money into this land which nobody wants. And it is sold to him. And there's evidence to show what is the market price. And the sale was at market price, registered also. Then they say, no, that is not the market price. Market price is something else. No evidence on what the real market price is. Still, the tribunal, my lord, says that the sale is not to be sustained, gave certain directions.
Whether purchaser was also a party to this?
Yes.
He was.
Party, yes.
Very well. We'll continue this. We'll also come out reading some
May I
judgments.
give
which
that
you said.
compilation tomorrow morning, my lord?
Very, not many.
No, not many.
How law, graphical
Yes, yes.
growth of law
Yes.
under this. That will be sufficient for us.
I made a separate compilation when I go to the facts, my lord, to substantiate my submissions on some 3-4 headings. I'll not give that now, my lord. I'll only give these leading 4 or 5 decisions.
Decisions which we will go through.
Please.
Yeah, and if you can, if you ask some of your assistants to prepare a gist of that.
Yes, certainly.
Like the
We'll-
cases and materials
Yes,
on criminal or Smith,
Yes,
Hogan,
yes.
etc.
we'll do
What
it.
they just they will say that way instead
have
of reading.
Some very enthusiastic colleagues, they will do it.
Very well.
I'll see it.
Thank you so much.
I'm grateful.
We learned, at least I learned lot of in this because very confusing it was when I read that text. Thank you so much.
Please.
Which date you want this matter?
How much time?
ನಮ್ಗೊಂದು 4 ದಿವಸ ಬೇಕು ಇಂಥವೆಲ್ಲ ಓದ್ಕೊಳಕ್ಕೆ, ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಈಗ ಸಿಗೋ ಟೈಮ್ನಲ್ಲಿ ನಾವು ಓದ್ಕೋಬೇಕು. ಅದರ್ ರೀಡಿಂಗ್ ಇರ್ತದೆ.
Compilation of case laws have already been filed, my lord, so both the sides. That is also there on record.
21, 22.
Okay.
Kindly.
Okay.
And with along with synopsis. It is there.
ಅಲ್ಲ ಈ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಓದಲ್ಲ ನಾವು ಆ ಕೆಲವು ರೂಲಿಂಗ್ ಲಾ ನೋಡ್ಕೊಂಡ್ಬರ್ತೇವೆ ಮತ್ತೆ ಸೊ ದಟ್ ನಾವು ಲಾ ಇಕ್ವಿಪ್ ಆದ್ರೆ ಮುಂದೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಇಬ್ರು ಅಸಿಸ್ಟ್ ಮಾಡೇ ಮಾಡ್ತೀವಿ.
My lord, may I request this, my lord, if your lordship should give us 2 or 3 consecutive dates in the afternoon or some time, so that other work will not, the record is somewhat bulky, so I have to take your lordship through some
Very
facts.
well, very well. We'll do that way only.
21, 22, 23, if that's okay.
Whichever date it's
Lordship may have it on 21st.
Very well.
And it can continue the next 2 days.
ಮ್ಯಾಟರ್ ಹಾಕೊಂಡೇವು ನಾವು 2 ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
Then 22nd.
22nd ಹಾಕೋಣ. Yes. Thank you so much. I am enlightened.
No, there's one office objection which I need to comply. There was an amendment of the cost title that had to be done, my lord. Your lordship permit us to.
Of the
All the
appellants passed away, my lord.
Huh?
One of the appellants has passed away, so the LRs have not been brought on record. Any of
Very ಸ್ವಲ್ಪ.
that is for them to decide.
ಅಲ್ಲ ಅವರು ಡೈರೆಕ್ಟರ್ ಅಷ್ಟೇನೆ. He is only
Death
a
of
director.
director ಏನೂ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ.
Like,
Director
joint and several liability is what is the thing, because we're relating to sale of the property. So execution petition was filed against all of them. And my lords, the part payment.
How death of director will
No, my lords, he was also party to the fraudulent sale of the property. That is our contention. And it is a joint and several liability that all of them have been made liable to pay for the fraudulent act.
ಡೈರೆಕ್ಟರ್ ಡೆತ್
And
ಆದ್ರೂ
in
ಎಲ್ಲಾರ್ಸ್
fact,
ಬರ್ತಾರ?
part of the amount has been
ಬರಲ್ಲ.
deposited.
What I'm saying, normal course ಅಲ್ಲಿ, not if he is
Unless ಅವ್ರದ್ದು ಎಸ್ಟೇಟ್ ಏನ್ರ ಇದ್ಕೊಂಡು that passes on to the hands
In
of
fact,
the persons,
my lord,
ಅವಾಗ may arise. But in matters like this
They
also,
have deposited the amount before this court and I have been permitted to withdraw that also. The sale consideration, whatever, my lord sees.
ನೋಡಿ ಹಂಗಾದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
my submission is not necessary, my lords. If the worst scenario is this appeal fails, he's already got his money.
No, no, I have not received. It is only
So
a
you cannot have-
conditional order.
That's
If I am unsuccessful, I will have to return that money. That is because they have even taken up the matter before the Supreme Court. I have given security and then drawn the amount.
ಅಲ್ಲ, then you can take up the contention.
That's
I
right.
want to return, but that person is dead.
That's right. No, the factual aspect, what has transpired. my lord,
ಯಾವ appellant is dead?
3.
Appellant number
Appellant number 3.
Mr. Sampath Raj.
Respondent number 3.
Appellant number 3.
Appellant number 3 is reported to be dead
Abate ಅಂತ ಆರ್ಡರ್ ಆಗೋಗಿದೆ.
as against him.
Yes.
But
26/2/24 ಅಲ್ಲಿ
Is there-
there is an order.
There is an order.
we'll have to amend the cost. Show it that.
ಅದೇ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ
ಆಯ್ತು,
ಇರೋದು.
ಆಯ್ತು.
ಅದೇ ಮಾಡ್ಲಿ.
ಮಾಡಿ.
ಅದೇ ಮಾಡ್ತೀನಿ.
Call on 23rd. In the meanwhile, the amendment of cost title to be carried out.
22nd and
22nd. All.
5:43 minutes.
afternoon, my lord, or
After whichever you want.
2:30.
Both of you. 2:30?
2:30.
All right, 2:30. Yes. Aditya appears in this matter.
I not,
No, in the previous company matter.
not, I don't know. Assisting you.
I pay for them.
Any, yeah, we have the 38,
19.
19. Can we have after 2 weeks?
Please.
Sumoto adjourned by 2 weeks.
Please.
But Yes.
Giving the other.
Tax matters.
Ah.
Against the Sumoto revisional order passed by the additional commissioner.
Sit on, sit on, sit on.
Sumoto power to revise is there?
No, it is there. We are saying it is technically we are raising that ground also. On merits also, we are before this honorable court. We are TKAP is a well-known auto parts manufacturing company in Bidadi. They had availed notification for exemption.
How much time it will take?
It will take half an hour at least.
Half an hour. So we'll have some other day.
Yes, but a date may be.
Short, ಒಂದು 5 ನಿಮಿಷದಲ್ಲಿ ಯಾವ್ದಾರ ಆಗಂಗಿದ್ರೆ ಹೇಳ್ಬೋದು. We have
5 ನಿಮಿಷದಲ್ಲಿ
some
ಅವ್ರು
judgment.
ಒಪ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಗೋಗ್ಬಿಡುತ್ತೆ.
ಮಾಡಬಹುದು.
ಹೌದಾ?
Actually, for the earlier year, it has been allowed.
Is it?
On merits, I will join issue with my learned friend.
Okay.
But what happens here, my lord, is that under 15(2) of the act, the additional commissioner para 5.
Sir, what is your argument?
Your lordships may kindly see, I have exercised power under 15.
5 is answered in the affirmative. Affirmative. He has power.
No, he doesn't have power.
He does not have power.
He says that he was justified
In law.
in levying penalty and so and so. Then what happens is, if your lordships may kindly come to para 7. Para 15 of the Karnataka Entry Tax Act provides for revisional powers of commissioner, additional commissioner, joint commissioner, and deputy commissioner. Commissioner has powers of revision as against an order passed by additional commissioner, joint commissioner, and deputy commissioner. Additional commissioner has power of revision as against the order passed by the joint commissioner. Joint commissioner similarly has powers.
Not have set aside subsequent assessment order.
The assessment order he could not have touched. In this case, the revisional power is exercised against a assessment order of the CTO, which is well below the rank of either joint commissioner or deputy commissioner sitting in appeal.
So he could not have done that.
But on merits, I will join issue with my learned friend. But
No, this on the jurisdiction. So we have to set aside.
But I am vehemently opposing his case.
Good. Barkat.
Lordships may see the order that I have revised Sumoto is at page 48.
Whose order you have revised?
My lords, of a commercial tax officer.
That you could not have.
Under 15(2).
CTO's order is revised.
Yes. That could have been done.
CTO's order has been revised.
And CTO's assessment order has been.
Assessment order has been revised.
Yes, my lords.
Revised or set aside?
Revised and
set aside.
set aside.
And set aside.
Revised and set aside.
It could have been done
by the additional commissioner of by the
joint commissioner.
Additional ಅಂತಿದೆ ಇದರಲ್ಲಿ
15(2) ಅಲ್ಲಾಗಲ್ಲ 15(3) ಅಲ್ಲಿ ಮಾಡಬಹುದಿತ್ತು.
ಅಲ್ಲಲ್ಲ order is passed by additional commissioner.
So that's what I'm saying.
That's additional commissioner of commercial tax. First off. Petitioner, the counsel for the petitioner submits that this power does not avail to the additional commissioner as against the orders made by the CTO. First off. Said contention is supported by a coordinate bench decision in Kirloskara Power Supply Company Limited. Nimma sister concern versus state. 2006 SEC online, Karnataka 934, wherein paragraph 5, 6 and 7 read as an. First, in view of that, petition is allowed. Allowed ಅಂದ್ರೆ ಏನು? Set aside ಮುಂದೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಅಷ್ಟೇ.
The assessment
petition is allowed. The impugned order is set at naught.
Your lordships may record my argument as being that The 15(2) says that refers to any proceeding.
Pakali. Aditya's contention that the terminology of section 15(2) is wider in as much as it employs the expression any proceedings, comma, is difficult to countenance in view of declaration of law by the coordinate bench. All. Right. Shatrak ಆಯ್ತಾ ಇದ್ದಾರೆ 45 one.
My name may be kindly be shown.
ನೋಡಿ ಹೆಸರು ತೋರಿಸ್ಬೇಕು. ಓಕೆ. ಒಂದು ಯಾವ್ದಾರ ಡೇಟ್ ತೋರಿ ಶಟ್ರೆ.
ಶಾರ್ಟ್ ಡೇಟ್ 30 ವರ್ಷದಿಂದ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ಇವತ್ತು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಲಿಲ್ಲ.
ನಿಮ್ಮ ಫ್ರೆಂಡ್ ಯಾರು ಇದ್ರು ಕೇಳ್ಕೊಂಡು ಡೇಟಾ ಫಿಕ್ಸ್ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ. ಇಲ್ಲ ಅವರು ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಫಿಕ್ಸ್ ಮಾಡೇವಿ ಅಂತ.
ಪ್ಲೀಸ್.
ಇಲ್ಲಿ ಸುಬ್ರಹ್ಮಣ್ಯ ಇದಾರಲ್ಲ.
May request for a week some accommodation, my lord. I could not come to the court because of a health problem, my lord.
All right. No issue. Get well.
Next week, my lord. Next
23rd ಹಾಕೋಬೋದಾ? 23rd ಹಾಕೋಣ?
ಹಾಕ್ಬಹುದು.
ಅವತ್ತು ಮಾಡಿಬಿಡಿ.
ಆಯ್ತು.
ಸ್ವಲ್ಪ
ಕಾಲ್ ಆನ್ 23rd at the request of counsel.
ಲಿಟಲ್ ಅರ್ಲಿಯರ್.
ಇಲ್ಲ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅದಕ್ಕೆ. ಕೆಲವು ಅದು ಗುಲ್ಬರ್ಗಾದ ಅಂತ 371J ಇವೆಲ್ಲ ಇದಾವೆ. ಇಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಇದೆ ಒಂದು. ಹಂಗಾಗಿ ನೋಡ ಅವತ್ತು ಮಾಡೋಣ. Yeah. Okay.
ಸರ್ ಮ್ಯಾಟರ್ ಕರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಟೋಮ್ಯಾಟಿಕ್ ಲಿಸ್ಟಿಂಗ್ ಆಗುತ್ತಾ? 41 ಬೇಡ, ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ ಅಷ್ಟೇ.